Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2021-88E. We're going to take roll. Present in the hearing room, we have Commissioners Caston, Thomas, C. Williams, Powers, Belzer, J. Williams, and joining us virtually, we have Commissioner Urban. Before we took a lunch recess, we were in the midst of cross-examination by Attorney Ellaby with Mr. Burgess on the witness stand. I'm sorry, I don't know why Attorney Ellaby is on my mind. Attorney Willoughby is in the midst of
Well,
cross-examination.
Mr. Chairman, I promise you, I've been called much worse. So I appreciate you calling on me. That's all that matters.
All right, please proceed, sir.
Thank you very much, Mr. Chairman, members of the commission. Mr. Burgess, good to see you this afternoon. When we left this morning, I was sharing my screen. Let's see if I can do it again. Are you able to see the screen and the order from the commission, order number 2020-244?
Yes, I can see it.
And we were talking about the fact that in the alternative, the order mentions that SBA witness Burgess recommended an integration charge of 96 cents per megawatt hour, correct?
That's what it says, yes.
And so the commission goes on in its order and it recounts some of the adjustments that you proposed. And as I remember, you were saying right before we broke for lunch that you had not had an opportunity in 2019 to do anything more than a high-level analysis, not as much detail as you've done in this case. Did I understand that correctly?
Yeah, so in 2019, I was working with the South Carolina Solar Business Alliance. And at the time, I was addressing a whole variety of issues related to avoided cost, not just the VIC, but also avoided energy, avoided capacity. And around the same time, I was working with Solar Business Alliance on Duke's avoided cost case as well. So simply, due to the limitations in my time, I didn't spend as much time diving deeply into the VIC charge back then, but I was able to do enough analysis to identify some mistakes and make some adjustments based on those mistakes, and that's what led to the 96 cents value. So in this case, I've done a little bit deeper analysis on the VIC, and that's what's leading to my recommendations in this case.
And many of the recommendations that you've made on this occasion or in this case are very similar to the recommendations you made in 2019, correct?
I think there's some overlap, yes, but they're not exactly the same.
So, and as we continue into the order, we note that the commission concludes the commission finds SBA witness Burgess's testimony compelling and adopts his recommended VIC/EIC of 96 cents per megawatt hour as it more accurately adjusts the modeling done by the company and provides a rate that more closely reflects the actual cost of integration. The commission emphasizes that this is a temporary interim value until a more accurate cost can be determined through an integration study. Once a more accurate rate is determined, the VIC/EIC will be subject to a true-up, either up or down, depending on the actual integration cost indicated by the integration study. Did I read that correctly?
You did?
And so your alternative recommendation of 96 cents was adopted by the commission based upon a fairly high level a critique. You initially recommended 0, and that wasn't adopted. Your alternative was 96 cents, and it was adopted. Was that 96 cents a reasonable recommendation when you made it back in 2019, Mr. Burgess?
At the time, based on the analysis I could complete then, I think it was a reasonable recommendation. But I also suggested that that may not be, if there were, if the full analysis were completed, that it may be even lower than that.
And so based on that, then so you come back in this proceeding and you're recommending 0 again, correct?
Correct.
And then we're saying, okay, we took 229 and reduced it to 96 cents. So now if we can take 96 cents and reduce it to not 0, but 20, correction, what are those numbers, Mr. Burgess? I've got them here, 28 cents on the first tranche and 71 cents on the second tranche, correct?
That sounds right to me, yeah.
And the only thing that you and I may agree on is that your recommendation of your alternative here, 28 cents and 71 cents, recognizes that as we go from tranche 1 to tranche 2, the VIC increases, correct?
In the alternative recommendation I put forward, that's true. Although, as I again said, that a more exhaustive analysis could show that the values are less than those that I put forward in my alternative recommendation.
Well, you've done a more exhaustive analysis in this case by your own testimony. We did a kind of a spitball approach in 2019, but we've done a more thorough analysis in 2021, correct?
Right. So when I do look at the historical data, how Dominion's operated system, and in fact, Guidehouse's own analysis, it shows that there's no need for incremental operating reserves for integration costs. But then I said, well, let's give them the benefit of the doubt. They're saying that there is a need. If we follow their methodology with these increased operating reserves shown in Table 11, that we still don't know how they came up with them, but assuming that's the case, then there's still some errors in how the results were formulated into the VIC. And when I correct for a few of those errors, then you get to the alternative levels of 28 cents and I think it was 71.
I've scrolled back up in the order, Mr. Burgess. Your team argued in 2019 that the VIC had to be fully and accurately designed to reflect the utility's avoided costs. Says that, doesn't it?
It does, yes.
So what is the fully and accurate reflection of the utility's avoided cost in this case?
I'm not sure I understand this question. What are you asking, if Dominion has calculated the avoided costs correctly so that it's full and accurate?
Well, I'm suggesting this. You have it calculated. And of course, your analysis of the avoided costs is purely limited to VIC. We've established that, correct?
Yeah, that's right.
So the only thing you can even offer a view on is the VIC. And you've admitted that you haven't calculated a VIC, correct?
Well, I think that there's a preliminary question of whether or not a VIC is needed in the first place. And I've done an analysis on that question and determine that I don't think there is, at least for tranche one. And then there's a subsequent question of, if you assume a VIC is needed, how would you then go ahead and calculate it? I haven't necessarily said that I agree with all aspects of the Guidehouse approach, but again, giving them the benefit of the doubt, if we start with the results of their analysis and apply corrections to the way they're then interpreted to formulate the VIC, then you would get to the alternative rates that I recommended, which I guess are, more fully reflective of the avoided cost rates under, Dominion's view, than what I would suggest.
But let's be clear, Mr. Burgess. All you're doing is taking the work that Dominion Energy South Carolina and its independent consultant Guidehouse has done, and basically arguing that mistakes have been made, corrections need to be made, and you've come up with your theories and you've made adjustments to the data that we've provided, to the studies that we've done, and said, if you accept my adjustments, then here is the result. That's what you've done, correct?
That would be sort of a characterization of the alternative recommendations I put forward, yes.
It's not my characterization. It's essentially what you've done. You said, if you make all of these changes that I recommend that you make, it'll be zero, correct?
Okay, so the zero recommendation is based on an analysis of the historical data and how Dominion has operated its system and the inconsistency with the level of increased reserves that the Guidehouse suggests with those historical data. So when you compare those and see, look at what Guidehouse is saying, there needs to be all these additional reserves added to the system, and you square that with the historical data, that just doesn't make sense in my view. And that's why the zero is the primary recommendation. But then again, I go ahead and say, we can, with a grain of salt, look at what Guidehouse has done. And, they've done some modeling work. They've, still not clear exactly, how that was done because there's some pieces of missing information, but assuming they've done it correctly, we can look at the results that were provided. And, with those results, there's still some problems. And so I did an analysis on those, and I looked at, I adjusted for hourly weighting. I adjusted for the cost allocation between the tranches, and I adjusted for an improved forecast error. And when you make those adjustments, which I believe are appropriate and more reflective of a full and accurate avoided cost, then you get to the alternative numbers that I put forward.
But to be clear, even the initial analysis reflecting your recommendation of zero comes from you taking all of the study work that Guidehouse did, the data that DESC provided, and you basically said, if you correct this and correct that, change this and change that, and if you assume that the operating reserves really don't have to be changed at all, it's zero, correct?
I would say that's less reflective of taking Guidehouse's study than it is my own analysis of the historical data that was provided, that minute by minute data, of the operating reserves over the last 5 years.
But so you did review in the process of doing that, you reviewed the Guidehouse.
Mr. Chairman, can the witness finish his answer?
I'm sorry, I didn't realize he was continuing to talk.
So that was sort of a new piece of analysis that Guidehouse didn't do, it doesn't appear that they've looked at the historical data in any detail in their study, and so I actually did that in my analysis and testimony.
So you came to the conclusion that Guidehouse didn't even do any initial analysis to make a determination whether or not any additional reserves were needed at all. And so their basic foundational point was wrong to begin with. That's what you came to, correct?
Right. Well, it looks like they did do some of that work, and then that's in, you know, the we were discussing earlier with CCBA 2-14, but that initial work was also flawed, and when you make corrections to it, you see that there's also no evidence for a need for increased reserves for tranche 1.
So now let's see here if I can.
But I should point out that was not based on a historical analysis. That was based on Guidehouse's model projections. So even, you know, with their model projections, they're claiming that there's these hours when there's a reserve shortage, but I don't agree with that because of the errors that were included in those work papers.
Well, and I'm not going to belabor this, but I want to talk with you about one of Mr. Hanslick's charts here. Do you see this exhibit from Mr. Hanslick for August 17, 2021?
Yes.
Mr. Chairman, can you see it as well?
Yes, sir.
So you quibble with the fact that operating reserves more than that they don't need any additional operating reserve. That's the foundational principle that you're advocating. But if you just take this point here, if I can get these little boxes that come up, let's see, so at 3:29 on this afternoon, 8:17 would have been last week, right?
Right.
So at 3:29 p.m., solar is producing 443 megawatts of generation, correct?
Looks to be right.
And then at 3:49 p.m., just 20 minutes later, it's down to 168 megawatts. In 20 minutes, you've got a drop of, what is that? 270 some megawatts of generation drops off the network, correct?
It looks like that could be the total drop, but again, it depends on the time frame you're looking at. So I think that's when I calculated it. You know, I actually looked at this in the testimony I gave orally this morning, and the 15-minute interval drop was about 251 megawatts when I calculated it.
Well, the math that you and I just did indicated that you went from 443 to 168. That's roughly 270 megawatts, isn't it?
Yeah, but I guess that'd probably be a little longer than 15 minutes. But yeah.
So it's 20 minutes, right?
Yeah.
So it's 20 minutes, 270 some megawatt drop. Picture Mr. Hanslick sitting in that control operation center. He's got to have power to respond to that drop, correct?
That's correct. And there's no indication from this that he wouldn't be expecting that drop, because we don't know what the forecast is. We also don't know how much reserves he already has on the system. Maybe he has 1,000 megawatts of reserves sitting there that could spin up within 10 minutes and accommodate that. You know, those are all very important details that factor into whether or not this is an unexpected drop that leads to a reserve shortfall, which is really the only thing that the VIC is trying to look at.
And isn't it true? Did you hear Mr. Hanslick testify, or has someone told you what Mr. Hanslick testified to?
I did hear his testimony. Yes.
So you heard him say then that these drops on all of these charts were unexpected drops, correct?
Objection to the characterization of the testimony. Not sure that's what Mr. Hanslick said at all, Mr. Chairman.
Well, the record will reflect that. Let's assume for a second that he said that it was unexpected drops. Mr. Burgess, he's got to have reserves to deal with that, correct?
Yeah, although I would say unexpected, it's a relative thing, right? Because you may have an unexpected drop, and it looks like in this case, the drop is going from, like you said, in the 400 megawatt range, 450 maybe, down to a little under 200.
443
Yeah,
down to,
right. So you can see from this graph that this is not all the solar. This is not the solar operating at its full maximum output. This day is, there's weather this day, and that was predicted. If it had been generating up at around 860 megawatts, which is the full output on the system, then you're talking about a different magnitude of unexpected drops. So while it may be unexpected, the magnitude also matters, and there's ability to predict what some of those relative magnitudes might be ahead of time, because we know what the weather's going to look like.
and I agree with you, the magnitude is important. If the generation had been at 650, you would have given the weather change, the weather pattern, it would have been a much more dramatic drop. Wouldn't that be true?
But it wouldn't have been 650 because it was predicted to be a cloudy day. And so there's no, that's just not a really a valid comparison.
Well, do you know that it was predicted to be a cloudy day? Of your own knowledge, not what someone's told you.
Well, we looked at the weather forecasts the other day. I think, and there was a tropical storm I think it would have been pretty well known that there would have been some overcast, cloudy conditions on a day like that. But again, it would be great to look at the forecast data, which wasn't provided as part of this, and then we can really see what they were expecting.
Well, let's take a look, but you've got would you accept subject to check that this drop from here to this drop to here is a 62% drop?
I don't know what time frame that is. It may be, 62% overall, but remember that the relevant increment for integration costs is 15 minutes. So to call it a 62% drop would be maybe that's correct, but it doesn't matter if it occurs over a longer period than 15 minutes.
Well, I'm not sure. You suggested it doesn't matter. I would suggest otherwise. The point I have is just a very simple question. In the space of 20 minutes from here to here, you've got a drop of some 270 megawatts of generation, which is roughly 62% of the generation drops off of the system and has to be replaced, correct?
It was about 250 megawatts, if I remember correctly.
Well, my calculations is about 270. Would you accept subject to check, or do you want to do the math? Do you have a calculator there?
Well, again, on a 15-minute basis, I think it's 251, but maybe on a 20-minute basis, it's 270.
Okay. Can you do the math, or will you accept subject to check? I've already done it. 446 down to 168, 20 minutes, and that results in a 62% drop in generation. Would you agree with that?
Over a 20-minute period, 62%, maybe that's correct, yeah. I subject to check.
And one final, let's look at one more data point. August 16, the preceding day, same calculation. At 4:27 p.m., generation 379 megawatts. $5:02, you're down to 110, roughly 30 minutes, and you've got a 70% drop in generation. You agree with those numbers?
It may be 70%, but again, it's hard, that looks like it's towards the end of the day. I mean, a lot of that might have been sun coming down and really an expected occurrence. You just can't tell without the forecast.
Have you ever visited South Carolina, Mr. Burgess?
I have.
Then you would know that at this time of year, that at 5 o'clock in the afternoon, there's plenty, especially with daylight saving time, we've got 3 to 4 hours of sunlight left, correct?
Well, yeah, that may be true, but it's also less than it would be at, say, noon. There's a regular pattern of solar output that you would see, and it does start to drop off even, in the late afternoon, even if there's more daylight left later in the day.
Would you agree that if you do the math, the two numbers we've mentioned here, 368 down to 110 is a 70% drop in a 30-minute time frame?
On 30 minutes? Sure. I would like to see what it would be for 15 minutes, but that sounds right to me for 30 minutes.
So let's get out of this. And go back, let's see now. Give me just one moment. I'm trying to get this exhibit, Mr. Burgess, that we had previously discussed. Here it is. Now, do you see the exhibit that I put up on the screen previously that juxtaposes Act 62 versus a FERC order?
I do.
Do you agree with me that if the 96 cents VIC charge, that's an interim charge today, is too low, that the customers of Dominion Energy South Carolina is at least temporarily subsidizing your clients?
Could you repeat that question?
Sure. Would you agree with me that if the 96 cents VIC is too low and insufficient to pay the variable integration charges that Dominion Energy's customers are currently subsidizing your clients, solar developers, for the difference.
If there were integration costs that in reality that were higher than that, then yes, but I don't believe that there are integration costs being incurred that exceed that.
And I get that. I mean, everybody knows that you think it's zero, that you've recommended it's zero. And we all get that you don't agree with 96, but I'm just asking you a principle. And the principle, I think you've agreed with it. You always want to explain, and I get that. But the principle is, to the extent it is too low, then the customers of Dominion Energy are being saddled with, at least on an interim basis, with the difference, correct?
Yes, although I think you'd also have to look at the totality of the avoided costs as well, because if it could be possible that, you know, maybe there's some degree of subsidization going on the integration costs, but perhaps the reverse is true on energy and capacity. So I think you'd really need to look at the whole picture to say one way or the other.
So the answer is yes. If the 96 cents is too low, the difference is being borne by the customer, correct?
Presuming there are costs being incurred, then yes.
And that would be in violation of the Act, would it not? The Act says must be just and reasonable by its very nature. Any charge that's not reflective of cost, not fully recovering its cost, is not just and reasonable. And the Commission is required to strive to reduce the risk placed on the using and consuming public, correct?
I mean, I'm not a lawyer, so I can't determine if that's a violation, but you know, I guess there's some merit to what you're saying.
Thank you. And would it also be true, let's look at these provisions on from FERC orders. Nothing in the text of FERPA requires the establishment of a subsidy for QS. Did I read that correctly?
Yes.
And where my cursor is, the full avoided cost rate requirement represents the maximum rate permitted under PURPA. Did I read that correctly also?
Yes.
The order also states PURPA does not guarantee QS a rate that guarantees financing. Did I read that correctly?
Yes, you did.
It does not provide a guarantee that any particular QF will be developed or profitable. Did I read that correctly?
Yes.
This is evident from the structure of PURPA, which caps QF rates at the purchasing utilities, in this case Dominion Energy's, not somebody else's, purchasing utilities avoided costs, rather than providing for rates that guarantee the recovery of a QF's costs. Did I read that correctly?
Yes, you did.
And then finally, the highlighted section here, the FERC in this case concludes that the record shows that on some occasions, long-term fixed QF rates were well above actual avoided costs, thereby causing consumers to subsidize those QFs in contravention of FERPA and the FERC's expectations. Did I read that correctly?
Yes.
Would it be true, Mr. Burgess, that in every recommendation that you've made in 2019 and again in 2020 has always been to recommend a position that would inure to the benefit of your clients, the solar developers, correct?
I guess, to the extent that a lower VIC is a benefit to solar facilities, then yeah, that would benefit my clients. I'd say the same might be true for Dominion in recommending a higher VIC, that it would benefit the company.
Well, you recognize that Dominion does not receive any profit out of its avoided cost. It's calculating an avoided cost designed to report to the commission accurately as possible what its costs are that it avoids based upon the solar generation that it purchases from your clients, correct?
I think that's what Dominion claims to be true, but I know we have different opinions on that.
We certainly have different opinions about the information that has been provided. There's no question about that. And I respect the fact that you've got a different opinion, Mr. Burgess. I don't quibble with you doing that. But what I do quibble with is what the evidence shows. Because if the commission gets it wrong, the customer is going to be the one that pays.
Objection, Mr. Chairman. Again, if Mr. Willoughby's going to have a chance to argue his position, he does. I don't see where there's a question here, and the witness has answered the question that he asked.
I don't think you let him finish, Attorney Burns.
Yep.
All right.
Thank
Sorry
you
about
very
that.
much, Mr. Chairman. I'll restate the question, Mr. Burgess. And this actually goes to a question that Chairman Williams asked another witness. I can't remember which witness. Had basically two questions. He said, on one occasion, he said, who should the commission be most concerned about here? And I think he answered his own question. Shouldn't we be concerned with the ratepayer, the customer? Do you remember him asking that question?
I remember something along those lines, but not the specific question.
And wouldn't it be true if, in evaluating all this evidence, and I would say, it's a tough job that the commission has. They've got you making recommendations, and then it's got company information, so it's got to evaluate that information and make a determination what is the appropriate thing to do from all of that evidence. But the point I raised to you in my question is this. The evidence that you have provided in this case is Mr. Burgess is taking essentially a study that has been done in great depth and essentially criticizing it on a number of key points that you think should be altered in the study. Correct?
What was the question there exactly?
My question is it the evidence that you bring to the table? Is Mr. Burgess taking the work of someone else rather than doing that work yourself, but taking the work of someone else and basically critiquing it and criticizing it and saying, you change this, you get a different result. You change that, you get a different result. You keep changing it, you get it down to zero. Isn't that basically where we are?
I wouldn't say exactly. I mean, I did provide quite a bit of novel analysis in this case. I did also critique the study, and but I don't think that those critiques were invalid in any way.
But you didn't do the in-depth analysis that the company did in terms of providing its avoided costs. And you didn't do a study like Mr. David did you?
Well, I guess, there's a preliminary question, as I mentioned, about do we even need to do a study in the first place? If we look at what's happened in recent history and find that there's no incremental reserve needs from solar, what's the purpose of doing the study unless you're looking much farther, focusing much farther out into the future? So, again, I think that the whole idea is that there may be integration costs that arise, but it's premature, and we can give the benefit of the doubt to the way the company approached the study. It's not how I would have approached it, but if we did it that way, we can fine tune it, make it better, and improve upon it. And that's what I've tried to do in my alternative recommendations.
And one of the points you try to make is you try to say Dominion Energy, South Carolina, with its recommendation, is trying to increase the VIC by 88%. You made that statement, didn't you?
That's right.
But the effect is, we all know there's an interim VIC, and you calculated that 88% by taking the interim VIC of 96 cents and saying if you go up to 180, that's an 88% increase. 180, $1.80, right?
Yeah, that's what I calculated.
Very simple math, but you acknowledge that the current 96 cents is an interim VIC, correct?
That's what the commission's order dictated, yes.
Subject to true up, correct?
Yes.
And you would agree with me, would you not, that the purpose of this proceeding is to try to make a determination of the avoided costs, both energy and capacity, for a number of categories, and at the same time determine what the VIC is, correct?
Right.
Chairman Williams,
Thank
Commissioner
you
Williams.
very much.
Attorney Willoughby, if you're finished sharing your screen, it would be good to be able to see your faces.
Okay. Well, I will be happy to do that. I'm glad to, I'm sorry to have kept it up there a little longer than it needed to be. But I would also say, Mr. Chairman, that I have concluded my questions of Mr. Burgess. Mr. Burgess, thank you very much for your attention today, and I appreciate having the opportunity to talk with you.
Thank you.
ORS.
Mr. Chairman, I think all of the parties have already indicated that they had no questions, at least what I thought.
Mr. Chair, we have no cross for Mr. Burgess. Thank you.
All right, redirect. I'm sorry, Commissioner questions.
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman. And thank you today for your appearance and your testimony. Mr. Burgess, seems to be a line of questions developed in this hearing about.
I'm sorry, Commissioner Powers, I hate to interrupt you. It's difficult to hear you, sir. This is Mr. Burns.
A little quiet for me too.
Okay, is this any better?
Yes, sir. Thank you.
Thank you.
Closer to the mic helps.
As I was saying, Mr. Burgess, there seems to have developed a line of questioning about who's getting paid what, and that experts are being paid. You think it'd be fair to say that everybody who's testifying before us is being paid?
Everybody, I don't know the answer to that, but it's different, obviously for a consultant like us, where we, our entire business is based on contractual arrangements for projects like this. Whereas I think for others, perhaps they're being paid, but it's more part of their day-to-day job, if that makes sense.
Well, as far as employees, they would also have what we would consider a degree of loyalty to the company that they work for as well, would they not?
Agreed.
And it's more likely that an employee is getting paid incentives or bonuses rather than someone who's hired to issue an opinion.
Yeah, I think that's definitely possible.
And your opinion is not based upon your payment, it's based upon your opinion.
That's right.
Okay. I want to ask you a couple of questions. I want to say on page 24 of your rebuttal testimony, there was some question about inconsistency from state to state as far as mitigation protocol. And your answer seemed to say that there's no evidence or any reason for North Carolina, South Carolina to have a different protocol. And, we deal with multi-state companies here a lot. And my question is, why should there be differences from state to state in a bordering state, or what's the basis of your statement?
Yeah, when it comes to something like this, I mean, the mitigation protocol is it's sort of a mechanism that there's a calculation that's done essentially that looks at how well did the solar perform compared to what was expected, and if it's underperforming, then you might be subject to the higher charge, whereas if you hit the mark, then maybe you can mitigate some of that charge. So but it's all based on sort of data around solar output, right? So it really doesn't change state to state. If you step across the state lines, it's not like the sun behaves differently. And so I don't really see much reason why you would treat the mitigation protocol in a different fashion. Dominion operates a system, I believe, similarly, in both places. And so it just strikes me as odd that you would have a very fundamentally different approach to sort of a technical calculation like that when the protocol developed in one place is probably just as good to apply it to another.
Do you know of any difference in the South Carolina or North Carolina law that require them to treat us differently?
I'm not aware of anything like that, no.
Okay, and you certainly understand that we're concerned with South Carolina ratepayers and with South Carolina citizens and wanting to make sure we get a fair shake.
Right.
Okay. I had just a couple of questions about the Fairfield hydro facility that you mentioned. You argued that this resource should be not under arbitrary restrictions, but should be used more, and that other resources are not a lower cost. Can you talk about that just a little bit?
Sure. I mean, I think the Fairfield pumped hydro, I mean, it's a phenomenal resource for integrating renewables. And I think Mr. Hanslick testified to that. It can start up quickly. It has a very significant capacity, 576 megawatts. And hydro is a very flexible resource that can really accommodate some of those sort of minute to minute changes that we see, from something like solar. So I think that if there's anything in the analysis that, Guidehouse or Dominion has presented that sort of arbitrarily or unfairly restricts that resource, it's going to have a huge impact on the results of the analysis. And so that's why it's important, I think, to really get a full understanding of what restrictions are being applied. It sounds like there's some, and we haven't really gotten to the bottom of it yet, but it could be that those are in some of the key times when you would want it to be helping to integrate solar, and that's what's driving some of these integration costs.
And I think you've been asked about it. There's some things you feel you haven't seen or haven't had time to see. If you had more time, what information you think would be helpful?
Yeah, I mean, that's one thing. As an example, there's probably some others I would need to spend a little bit of time putting together sort of a full list of additional questions. But another example would be it doesn't appear that we've gotten to the bottom of a few things on how they calculated the incremental reserve requirement. I mean, for example, the work papers I saw didn't really show which proxy sites from the NREL data were selected for each facility. I mean, they had the sites in there, but they didn't show how they selected it. They didn't really show how they calculated the forecast error for each increment at each facility. They didn't really show how the forecast errors were aggregated into a system-wide total. They didn't show, how these forecast errors were then being used in that Monte Carlo simulation. So there's a whole bunch of things I'd still like to sort of try to gain an understanding of, but we just haven't really had time in this proceeding to do it.
Okay. Well, with the schedules as they are, do you think maybe the company that hired you waited too long to get started, or did not give you ample opportunity, or really, I guess the question is, if there was more time, you think it would change your conclusions?
I don't think it would significantly change the conclusions. I think it would give us some more insight maybe into some of the reasons why we're seeing, very high levels of recommended reserves from Guidehouse versus what, I think is more reasonable. And that's what's driving, and those high levels of reserves are what driving the integration costs. So I think it would just help us understand, again, where some of the methodological flaws are in greater detail. And then, maybe give us some ideas about what we could do going forward, as the I understand it, the commission or someone may be conducting another integration study, and we could see what things we might want to take away from this experience or where we might want to avoid pitfalls down the road.
Okay. There's one other thing. You raised an issue about Dominion and about, stakeholder involvement. What would you recommend Dominion do as far as what you see as necessary stakeholder involvement?
Yeah, I mean, it's a little surprising to me that, we're sitting here again 2 years later and there hasn't been any, as far as I understand it, effort to sort of develop a stakeholder process to get input to these studies. But what I think maybe would make sense is, there could be a series of workshops, maybe that's hosted by the commission, to sort of come up with some agreement on the study methodologies and inputs. And then, a consultant, could be someone like Guidehouse, but could be someone else that would then go and take that input and conduct the study, with the benefit of input not only from Dominion, but from other stakeholders. They would have, a draft produced, and then stakeholders could review that and make comments and suggest changes, and then maybe a final study is produced subsequent to that.
Okay. Thank you, Mr. Burgess. Thank you, Mr. Chairman.
Commissioner Caston.
Afternoon, Mr. Burgess.
Good afternoon, or good morning for me.
Still afternoon here. Actually, Commissioner Powers maybe think of these things on relative to the water resource, I guess the reservoirs you were talking about. And I have no insight to the particular reservoir. But are you aware that, at least in my experience, most reservoirs, whether federally owned, state, municipal, whatever, have generally some sort of restrictions, either federal, state, contractual agreements. They all typically have some kind of restrictions. Are you aware of that?
Yeah, that is true. I'm aware of that.
So do you know in this case if any of that exists?
For this facility, I don't know what specific restrictions might exist. I do know that it's, right next door to the nuclear power plant, and that's a common thing you see where these pumped hydro facilities were built with baseload plants like that. So basically you could generate power and pump the water uphill at night, and then have it available to generate during the day. And so it is, I think it's been used for that purpose in the past, and now it has a new function with this integration issue, but certainly any sort of flexibility it can provide would need to be balanced with those other restrictions too, and I'm aware that those could exist. But as we heard from Mr. Hanslick, that they do seem to use it, at least on some occasions for this purpose.
Thank you. And relative to stakeholder process, I heard you mention that in your answers to Commissioner Powers. So should that stakeholder process consist of Dominion, ORS, and the, I guess, solar groups?
Yeah, I think it could be held as a public stakeholder process. There could probably be procedures implemented to protect any sort of confidential information, but I wouldn't see any reason why you couldn't open it up to several different parties, including ORS, CCBA, the other parties to this case, essentially.
Should it include a robust group that has some interest that may not share the same view as the solar companies?
Could you repeat that question, please?
I guess what I'm asking is, it sounds like you like the idea of the stakeholder process that includes this group, I guess CCBA and the others. Would you support a robust stakeholder group that involves the consuming public, the customer base, folks who may or may not share the view of CCBA, that may oppose your views?
Right.
Would you share that view?
Right. No, I think it's fair to include, any interested party, but hopefully there would be consensus drawn upon it. One thing I should mention though, about this kind of stakeholder process is that there's an issue in front of the commission right now about the VIC, and I would hate to see, a stakeholder process essentially just kind of delay any sort of decision on that, because from what I'm hearing, there's a lot of uncertainty right now among the solar community that with that interim VIC out there, and if we have to wait another year or two for any more clarity on that, that's a major issue. And while I support a robust stakeholder process going forward, I do think it's important that there be some conclusion on that sort of interim VIC that's in place today.
Thank you. And since you brought that up, so it is your testimony that a VIC does not even need to be calculated?
Right, at least for now, with this tranche one that we have, it appears that, there's a sufficient integration capabilities at no real additional cost. So, I think that makes sense that, you wouldn't necessarily have a VIC applied for those facilities. Now, we can look out into the future. We can look at, if we integrate another 800 megawatts of solar onto the system. And in that scenario, I think that we would start to see a need for maybe some incremental reserves. That analysis, I think, still needs to be done. I don't think that what Dominion put forward constitutes a sufficient analysis for that. But yeah, I think that would be maybe the purpose of such a stakeholder process, is to look at that future scenario and say, what would the integration cost be with a lot more solar on the system?
So when you say that stakeholder process, you're talking about a stakeholder process to determine if there is a VIC or what the VIC should be?
Well,
Is that what understood?
The starting question, right, is like, do we need a VIC today for tranche one? Do we need a VIC tomorrow for tranche 2 and above? I mean, we may find that there's less of a need than we thought. I've seen that in other utilities. Like there was one that I worked with in Arizona that, a few years back, they were like, well, we think the integration costs are $20 a megawatt hour. And then they did the analysis and came back and found that they were, like $1 or less. So it really changed the view once they had the opportunity to take a closer look at the issue. And so, you could take that closer look and say, well, we don't actually need it right now, or maybe, we need a very low level of VIC, or maybe it's something we need in a few years' time once there's more solar on the system.
Okay. So you believe that intermittent solar resources produce no integration costs?
No, that's not what I'm saying. What I'm saying is that there's a lot of the integration challenges of solar that are sort of embedded in other, other costs that are part of the avoided costs or part of the way that Dominion operates the system. Just as an example, Mr. Hanslick talked about the curtailment issues they were facing, right? And they had, too much solar on the system, the reservoir was full, they had to curtail. So if that's introducing a cost, I would expect that to show up on the avoided energy side of things. If the analysis is done correctly, it would be showing that avoided energy cost at that time is very low, and perhaps even zero, because you're trying to actually avoid having to generate power in the system. So that's an integration issue, but it's a different issue than what the VIC is trying to reflect. And it's an issue that is already captured in the other avoided cost element. So the VIC is a very narrow thing to look at. Do we need additional operating reserves for a very specific purpose, which is these unexpected 15-minute drops? And so for that specific purpose, what I'm saying is that the evidence doesn't support a VIC at this time for tranche one.
But it is your testimony, though, that the VIC should be $0, correct?
That's right.
So what if the VIC that God House says it is, what if that's more accurate than not? What does that do?
Not sure I understand the question. Are you saying,
Well, I guess what I'm saying is, what if it's not zero? What if the VIC is not zero and there is a true up, correct?
right? Oh, so meaning we change the interim to a non-zero value. Is that what you're saying?
Yes.
Right. So I did put forth also in my testimony a secondary recommendation, which was if the commission felt that a non-zero VIC was appropriate, that they should set it at a level of 28 cents per megawatt hour. That's specified in my testimony. And that's based on basically giving the benefit of the doubt to the Dominion study and taking the results of their analysis, and then applying a few additional improvements to that because they didn't do the proper hourly weighting, for example, and a few other things. When you make those improvements, you land at a VIC of 28 cents per megawatt hour.
Okay, when kind of building on that, then Mr. Searcy stated that, I'm paraphrasing mostly, that his analysis and requirements were more detailed with a more deeper dive than ORS performed. Are you saying the same thing or a similar thing? That your analysis is more detailed? You take a deeper dive than ORS and
Yeah, it sounds like maybe we're in a similar boat there. I don't know exactly what analysis ORS conducted for, supporting their testimony on the VIC, but I would note that ORS did agree with me that the level of operating reserves that the Guidehouse recommended wasn't supported, or he couldn't determine, if that was reasonable. So I think that, we're on the same page on that point. And then as far as the analysis goes, I think we probably did do a little more, but again, I can't really testify to what they analyzed.
well, you stated earlier that you ran no models and you've never performed a VIC study, but your analysis goes to a greater depth than ORS. And I assume you read the testimony of Mr. Ori and the other ORS witnesses. You do agree that analysis, studies, models were done, evaluated by ORS and their witnesses?
Did they run a model? I can't recall if they said they did or not. I maybe recall that.
Did they evaluate the models and the data that was given to come up with their recommendations?
Yes, I believe they did.
Do you remember what the recommendation was for the VIC?
I believe ORS's witness, Mr. Horry, recommended that the VIC stay at the 96-cent level until the integration study was completed. But again, I also point out he did share my conclusion that there's the level of operating reserves recommended in the VIC study wasn't supported. So that was the basis for my recommendation for the zero VIC.
So you recognize that ORS is...
My similar conclusion that, that they hadn't justified an increase in the operating reserves.
you're saying that ORS had not reached a conclusion that, is that what I've heard? That they have not reached a conclusion that it should be greater than 96 cents? Is that what you said, or I missed it? Would you mind repeating that?
Yeah, so I guess there's two parts to this. One is that they agreed with me that the VIC study didn't, fully prove out how they, why the incremental operating reserves they're recommending are, what they are. And like I said, that's my analysis and my testimony shows that there's no evidence that there should be any increase, let alone the increase that, Guidehouse is recommending. And that's the basis for the $0 value. But ORS doesn't recommend zero. They recommend just kind of maintaining status quo at the 96 cent level until another study can be done.
So ORS recommends that a VIC study be done to try to determine a more accurate or real, what the more accurate real VIC is, correct?
Correct.
Will the data that's used for this new VIC study, will it not be very similar data that was used in the is it Guidehouse? Study?
A lot of the data in the Guidehouse study could probably be used in the VIC study. There may be some differences though. You may want to use a different solar forecast, for example. But, a lot of the data, especially around the utility generation unit characteristics and and those sorts of things, you would probably want to use again.
Okay. If I understood Mr. Willoughby correctly, he said Dominion provided you all the same information that had been requested by and received by ORS and other parties. Is that true?
I believe they did, yeah. I reviewed discovery responses that were requested by ORS and other parties.
And that was when on or around July 13th?
The July 13th was, I think that was the date, the original date of intervener testimony deadline. And then some of the discovery responses were provided after that date. Some, the ones that SCCB had requested at least. Some others we got before that date, back in, prior weeks.
And as I understand, you were retained by SCCB on or after July 1st, 2021, correct?
We were having conversations before that, but I think that's like the sort of date that it was finalized. Around late June or early July. I have to confirm that. Yeah.
Well, I guess what I'm trying to understand is other parties, ORS, received the same information, got what they asked for, did what they did in the time frame allotted. And why was this enough for them and does not seem to be enough for you?
Well, I believe that, I don't know if that's exactly true. In fact, let me just pull up, I'd written down this reference because I thought it was interesting. This is from ORS witness Horry's direct testimony on page 8. It says, however, through my review of the company's calculation methodology, I find that Guidehouse has not justified their forecast of incremental operating reserves needed to accommodate solar forecast uncertainty. So, I mean, from my interpretation of that, it sounds like they haven't gotten all the information that they needed to justify that, to determine if that was justified or not. And that was the same boat we were in, is that there's these other modeling steps that Guidehouse used that we never got access to, or was never represented. Like what are the underlying formulas to this? And so, yeah, that's something we struggled with.
Well, I can't put my finger on it right now, but I remember somewhere in the review of Mr. Horry's testimony, when asked about the transparency, I think his response was something along the lines that they were reasonably transparent. That's what I recall. I don't recall him saying they were not. So, do you believe that Dominion Energy discriminated against you and Sasiba relative to, I guess, sharing information, transparency?
I mean, at times it felt that way. I don't know if it was intentional or not, but I think what strikes me is that it seems like a lot of this information could have been provided back in April as part of the original application. So I don't know why, it wasn't. And it also, it takes some time to sort of unpack this stuff, especially when, even if some of the initial work papers, they were provided earlier, in fact, even before the testimony was provided. So it's like we're staring at numbers on spreadsheets, but we have no idea what they mean because the testimony hasn't been provided yet. And that didn't come until June 29th, I believe, right? So that's 2 weeks before our testimony was due, and you're trying to scramble to figure out, okay, now we can finally interpret these spreadsheets, but once you interpreted them, then you have to prepare additional discovery requests to get more information. And then by that point, you're out of luck because we're getting data responses back after our deadline, and we can't really dig in as much as we'd like to. So that was that's kind of the situation that we were in.
If I'm not sure what information you were talking about could have been replied, I guess provided in April. I'll let you elaborate that on briefly in a minute. But if the information was provided in April, and you said they received something in June, you did not begin until July 1st or later. So whether it was provided in April or June 29th, if you didn't start before July 1, why would that matter?
I'm talking about when it was provided to ORS, the date of that response. So regardless, the point is that there was no testimony filed until the end of June 29th, which is what we needed to interpret any data that was already made available. So you have data, but it's kind of, gobbledygook until you have some context around that. What does this mean? Which part of the testimony is this actually supporting? And so, even if there was more information, more information provided to SECIBA earlier, like they still wouldn't have been able to interpret it correctly.
All right, thank you. Let me pivot to a couple other things. Earlier, I think it's in your question with Mr. Willoughby, when you guys were discussing the monthly average, I think of drops, good way, best way. Do you recall that monthly versus minute by minute? Are you saying that a monthly average, I guess, of these demands, peaks, drops, whatever, are a good way or better way to determine operating reserves?
Could you repeat that question?
Are you saying that a monthly average, rather than the minute by minute peak drop of solar output, is a better way to determine operating reserves?
No, I didn't. I never meant to suggest that from an system operator's perspective, they should have a monthly value. Now, that's what Guidehouse's model uses. They have a fixed monthly number that they use. But, as we heard from Mr. Hansley, they're adjusting things in real time, responding to, each minute. So I wouldn't recommend a monthly value like what Guidehouse has done in their analysis. What I did include in my testimony, though, were some monthly numbers just as a sort of an indicator of what's going on in those minute-to-minute values, just so we could get a sense from a high level, how is the system working today? But it shouldn't be equated with a recommendation of that's what the reserve levels should be for a whole month.
So you would agree then that a monthly average of peaks or drops, whatever, I guess over a continuum, say, of 10 years could mask these precipitous drops in a 10-minute period or 30-minute period or 20-minute period. Is that correct? Do I have a reasonable understanding of the difference between averaging and looking at smaller, well, like the graphs that I
Yeah.
guess Mr. Hensley?
Yeah, right. So, I guess here's what I would say in response. If you look at the Guidehouse approach, they're setting a monthly value for operating reserves for all hours of the month. That is meant to protect against just a small handful of times with those drops, right? And so what you can see from that is that during most of that time, it's way above what it needs to be, and doesn't reflect those kind of real-time adjustments that Mr. Hanslick's team would be making. And so even though there may be, in the future, like, a handful of these hours where you have an issue, you wouldn't necessarily set your operating reserve levels at that sort of maximum value all the time just to cover those handfuls. You would do it in an intentional way to look at, okay, what's the solar output look like for this next day, and we'll ramp it up, as the sun comes up, not, kind of setting it at a flat peak. And so that was one of the issues that I had with the Guidehouse approach, is that they didn't sort of include that kind of responsiveness, if you will, that the system operators normally take to how they plan the system.
Well, that's probably a good segue into my next question here. What is a Monte Carlo analysis?
Yeah. Monte Carlo analysis is when you usually when you have a large data set that you want to gain some understanding of probabilities on, that you would essentially take random draws from that data set to reflect probabilistic view of many possible situations. And so, this is when you're thinking about power system issues, planning issues, especially when you're thinking about things like resource adequacy, will we have enough generation to meet the peak? Those kinds of analyses can be useful because we can look at, oh, okay, over the past maybe 30 years, like here's all the different load we've had on our system, and we can sort of pull out different scenarios from that data to sort of test and see how often would the system fail, like under a certain scenario. And so that's what Monte Carlo analysis is useful for. What's odd to me about the way it was described in the Guidehouse study is that they basically took 1 year of data and then did this Monte Carlo analysis on it. And so it didn't make a whole lot of sense to me why you would do that and not just use the actual year of data to look at those 90th percentile conditions. There's no reason you have to sort of bury it in a Monte Carlo model to look at the actual data. You're not generating any new information by running that Monte Carlo simulation. You're just sort of repeating the same data that you could have had a whole look at from the get-go.
Well, as I've said more than once, I am certainly no Monte Carlo expert. Couldn't do it. I couldn't run it. But I have a reasonable, I think, understanding based on what we've had to do. And you talked about 1 year data versus 30-year history. And I may be wrong, but I thought my understanding was more, it was well used when you have multiple variables. A lot of different things going on, a lot of unknowns. And one of the reasons it is done is when you don't have either a lot of historical years of data, or whether you do or don't, because you're still trying to plot a probability distribution, as you say, 98%, 2%. And for example, when I was thinking in terms of stream flows, trying to determine what's the drought of record, what should we use? And there's limited data because stream gauging stations weren't on that river, or maybe weren't put there for 50 years. So it's my understanding, such as that was why you want to use Monte Carlo analysis. Nothing more than, okay, we have all these variables, but we have this information, so we're going to run this iterative process over and over and over with all these different what ifs to come up with a probability. Say, okay, at this point there's a 2% probability that the stream flows will be below this level any given year. Does that make sense?
I think I understand what you're saying. I mean, yeah, it does make sense. And I, again, there are certain times when you would want to use a Monte Carlo simulation. I'm not sure if this is one of them though. And it's a little hard to tell. I mean, we're sort of, in the dark here because we haven't gotten the information about, what the algorithm was exactly. I mean, they're applying this to solar forecast error, is my understanding, to get better sense of the potential reserve shortfall. But again, the exact steps that were taken in running that simulation have yet to be provided. And so, you know,
Would,
I don't disagree that Monte Carlo can be a useful tool for looking at probabilities, but is it in this case, and was it applied correctly? That's something we still don't know the answer to.
but would you agree that relative to, if you're looking at a 1 in 10 case, 1 in 10 years, the worst event or whatever in 10 years, 100 years for that matter, 500-year flood, 500-year drought. Would you agree that what we're discussing now relative to, do you agree the weather varies? Demands, peak, drops, they vary. They're linked to the weather. But do you agree that there are multiple variables in what's being discussed relative to avoided cost and VIC?
I would agree with that, but again, I don't know how those variables were linked, if at all, in this Monte Carlo simulation. It was never really well explained, and the steps used were not divulged. So I would hope that there was maybe there was some attempt to link the solar output and the load or something like that, but we don't really know the answer. As far as I can tell, it was only applied to this solar forecast error, so a single variable, and every time we sort of asked about the formulas used, the answer was, well, it's buried in the model and we don't have formulas to provide for you. So I just can't assess, again, whether it was used in the way that you described.
Or could you have asked what variables they used? I mean, if you were concerned that they only used weather, could you said, did you use anything other than weather? Did you ask that question?
I think we asked some questions around providing, underlying formulas. And some of the responses suggested that they didn't have them or didn't obtain them. So we felt like we were just kind of banging our heads against the wall there and trying to get more information on that.
I understand. And you did read the Guidehouse study, correct?
I did.
Okay. Thank you, Mr. Burgess. I saw your door kind of crack open, so I don't know if your dog's got long arms or perhaps you have someone sneaking in on you.
Might be, or it could be my 1-year-old son trying to sneak in here.
All right, thank you.
All right, Commissioner questions for Mr. Burgess.
Mr. Chairman.
Vice Chair Belzer.
Good afternoon, Mr. Burgess.
Good afternoon.
I just wanted some clarification on one point.
Sure.
When Mr. Willoughby was questioning you about the graphs, which are contained in Hearing Exhibit 1 and had were showing the drops in solar production on various days, you recall that?
Yes, I do.
You referenced several times a 15-minute time frame. Can you explain to me the significance of the 15-minute time frame with regard to the drops in solar production?
Yeah, I'll try to do that. So the 15-minute time frame is linked to the fact that the Guidehouse study methodology uses 15-minute increments to look at whether or not there's an operating reserve shortfall. And the reason they do that is because it's tied back to the NERC standards. And I did talk about this a little bit in my supplemental testimony that I provided earlier. So basically, and I just might try to pull that up quickly. Yes, so the drops are calculated on a 15-minute increment, and that's linked to the NERC reliability-based control standard of BAL 001-2, which requires utilities to balance their generation load on a 30-minute average basis. So what Guidehouse did was to be, somewhat conservative. They said, okay, we're going to look at any sort of deviation that occurs on a 15-minute basis and say that's what we have to watch out for to meet the NERC standards. So, and if there was a shortfall on that sort of 15-minute basis of reserves, then they would need to essentially add reserves to maintain compliance with the NERC standard. So that's why the 15-minute is the most important thing to look at when you're trying to determine, do we need to add reserves to the system or not? And so, you can look over a longer time period at, 6 hours, or, but that's not going to be the sort of relevant time period for considering these sort of almost instantaneous drops that trigger potential reserve shortfall.
Okay. Thank you, Mr. Burgess. I appreciate that explanation. That's all I have, Mr. Chairman.
Commissioner Williams.
Thank you, Chairman Williams. Witness Burgess, I'm impressed. It's been a long day, and you're still laughing over it. On page 2 of your rebuttal, you state that desk operating reserves are not what they have been in the past, or not as great as desk currently maintains. Is this reason, the fact that there aren't growing numbers of operating reserves, is that enough to eliminate the VIC by itself?
Well, I certainly believe it is for tranche 1, which, most of which is already on the system today. So the point being, we look back 5 years ago, we see a certain level of reserves were there. We look at what it is today, it's similar, and we've brought on over 800 megawatts of solar. Most of tranche 1 is already there. So just looking at that before and after, it doesn't appear, that there's been a huge increase. Now, some of the reserves are being used to support solar, whereas before they might have been used, either they were just there because that was, the most economic way to operate the system, or they're being used for other contingencies. But the point is, you're not adding to that total level. You're maybe reclassifying, but you're not adding. Now, going forward, when we get into tranches 2 and 3 and, additional solar, then I think that's when you might need to start taking a closer look and say, okay, we now need to start adding some more operating reserves to the system to accommodate that solar. But again, the point being is, like, at some point in the future, yes, it makes total sense to increase reserves. I don't think we're quite there yet, but we may be getting close at some point soon.
Okay. Moving on, if we accept the interim VIC cost going forward, and I realize that as an interim, and I realize that's not what you're recommending, do you have recommendations for the path forward in terms of, we're just kicking the can down the road. How do we come up with a VIC? And I'm particularly a little bit confused about the relationship between, if we do that, the relationship between that and the statewide integration study that was identified in the Energy Freedom Act. I realize one is territory based and the other would be more statewide system related, but is there a key interrelationship between a VIC for one of the independent utility companies and a bigger integration study that might be needed on a statewide system? I've probably asked multiple questions in there, and you've been really patient listening to them. You want me to break it up?
Yeah, maybe if you could break it up a little bit, but I can try to take a crack at the last part there. I think, I don't know what you all or other stakeholders have necessarily envisioned for the statewide study, but I suppose, one element of that could be, trying to assess at a individual utility level, like what those integration costs might be. And there are other aspects of integration, as I mentioned earlier, that need to be considered too, that aren't necessarily related to the VIC and the increase in operating reserves, but still need to be evaluated. So I suppose, some of those issues should also be looked at in the study. Maybe one component is to do this sort of more objective analysis of the integration costs and the VIC as well for each utility. But again, that's sort of, I don't know all the details of how, what that study entails.
Thank you. I appreciate that's a fair answer. I think we don't know that yet. Then my last question relates to the mitigation protocols. The easiest question you've been given thus far, I believe, is that on page 33 of your testimony, you reference an Exhibit B. When I look for the Exhibit B, in the version that I have, and that Exhibit B was the protocol Dominion developed for North Carolina as a starting point for South Carolina. So I'm assuming, is Exhibit B the mitigation protocol that Dominion developed and was accepted in North Carolina?
That's what I intended for it to be. I don't know if it didn't get attached, or how I wasn't part of the filing process. So I'm sure that our attorneys can get you a copy of that if you don't have it.
Well, there is an attachment. It's just not labeled Exhibit B. So here's what I think it might be, and I want to check. And I can't participate in the award for displaying information. So although I might get some help, but it's very simple. So I don't think we need it yet. What I found is labeled Protocol for Avoidance of Solar Integration, RE Dispatch Charge. And if you'd like to see it, I have an able assistant who's willing to show it to you.
Sure. Yeah, maybe I'll just take a quick look, but that sounds right.
Yeah. The second to last, well, I'll let her show it to you. That's the front of it. And no, I want that. Where I'm going with this is to ask you about the North Carolina mitigation protocol and what was proposed by Dominion, because we really haven't had a lot of testimony in that regard. So I wanted to open that door for you. But in trying to make sure I was looking at the right thing, you can now, or will soon be able to see what I think might be Exhibit B. So if you could take a look at that when you can see it, and let me know if this is in fact the North Carolina approved mitigation protocol, that would be great.
It looks, yeah, this looks right to me.
There's a second page.
There should be another page or two, I think, maybe.
If you'll show on the back side, we'll just be really confident that we're looking at the right thing.
Mm-hmm.
And I even see on there Dominion Energy, or DENC. Are you able to see it yet?
Yeah, I just actually called it up on my screen as well, just so I can read it more clearly. But yeah, that's the right document.
Great. Thank you to our able assistant. Yes, we're good. She gets the award over here. So, Mr. Burgess, the point of my questions was just to understand, because you recommended that we utilize the protocols that were adopted in North Carolina, and to understand the differences between the two and why you would recommend the North Carolina adopted protocols.
Would you like me to explain?
I would love for you to explain. Yes, please.
Yeah, so I explained this in more in depth in my direct testimony, but there's a few problems with the proposal in this case for the mitigation protocol. Just to give you an idea of a couple of them, one is that Dominion proposes to calculate the mitigation based on a percentage basis of solar output. So what that essentially means is that if you think about it, so there's not the same amount of solar generation at all times of the day, and if in the early morning and the late evening, you still have some solar production, but it's very low, which means that if you have just a little deviation here or there, it can amount to a giant percentage change in that total production. And so, but the problem is that Dominion's calculation it basically takes the maximum percentage value that it locates across an entire month, and then says that's reflective of poor performance because you had this wild swing. But when you think about if you're just deviating a megawatt or two in the evening, that's going to have a very minimal impact on integration costs on the system, versus a much larger megawatt change that could occur in the middle of the day, but maybe that's only 1 or 2%. So basically the formula that they're using is kind of skewed because it's always going to overestimate sort of the poor performance of a solar resource, just based on sort of that daily, kind of fluctuation that's normal and expected. The other thing is that it takes the maximum value for the entire month. So that kind of penalizes the solar facilities in the sense that, it doesn't really capture how well they're doing in any, over the course of an entire period. It doesn't also really capture what's else is going on in the system, and if they were really contributing to any sort of integration costs. So I just think from a number of standpoints it has these issues, and so those issues would essentially lead to no ability to find a meaningful mitigation. It seems more designed to just make sure that the maximum integration charge is applied. I find it very different when I look at the North Carolina situation, where they have a different methodology, a different approach that addresses a lot of those issues that I identified in South Carolina. And I explained that in my testimony, but it has a different sort of calculation method that is not percentage based, but it is actually truly a megawatt value based. It basically overcomes a lot of the problems that I saw in Dominion's proposal here in South Carolina.
And has there been a stakeholder process related to mitigation protocol for that kind of information to come forward that you're aware of?
I'm not aware of it. Maybe it's happened somewhere, but I don't think it has. As far as I recall, I seem to recall a discussion with my client about this being sort of the first they've seen, in this case of this proposal for mitigation protocol.
Thank you very much, and good luck, because there's still a few more of us out here to ask you questions.
Great.
Are there any more questions for Mr. Burgess? All right. Any redirect?
Yes, Mr. Chairman, I do have a little bit of redirect.
Okay. Before you start, Attorney Burns, let's take a quick
Perfect.
break. Let's come back at 3:25.
Thank you.
Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2021-88E. Let's take roll. Present in the hearing room, we have Commissioners Caston, Thomas, C. Williams, Powers, Belzer, and J. Williams. Joining us virtually, we have Commissioner Irvin. Before we had a brief recess, we were at redirect with Attorney Burns. Please proceed, sir.
Thank you, Mr. Chairman. Mr. Burgess, I just wanted to discuss a few matters with you that Mr. Willoughby brought up in his cross. And so if you'll bear with me real quickly, I want you to recall, do you recall questions Mr. Willoughby asked you about discovery and when you received the information and how long you had to work on it? You remember that line of questions?
Yes, I do.
Do you recall, did you review the application filed by Dominion, its original application for its avoided cost rate?
Yeah, I did take a look at that, but there wasn't much to look at, to be honest.
And when was that was filed in around April, is that right?
Yeah.
And did it include the information that that was requested by CCBA in discovery request later on in the summer?
No, it basically, from what I could tell, it just had the rate, that was being proposed. Didn't have any sort of supporting data or analysis or anything like that.
Did it even include the Guidehouse study at the time?
No.
Did you review the first amended application filed by Dominion? After
Was
the commission ordered them to file an updated application?
Yes, I think that was the one was it June that came out? Okay.
Did that include the additional information you expected to see?
No, it didn't.
Okay. I want to show you what's previously been identified in this proceeding as CCBA cross-examination Exhibit 1, which is just the statute that's been referred to many times, Act 62. I want to direct your attention, and for everyone's information, this is section 58-41-20, down to subsection J of that section. Could you read that section that's highlighted to the commission, please?
I think so.
I'll blow it up for you.
Sure.
Is that okay, or does it need to be bigger?
It's okay. Yeah.
Oh.
It says,
Mr. Chairman, I would make this observation that Mr. Burns is going into areas that I really didn't go into. If he wishes to do that, understand that that's going to open the door for me to cross-examine this witness about it. I mean, we all understand what Section J of the statute is. We all understand that Mr. Burgess has indicated that he didn't get sufficient documents, but I didn't go into any of this. And if Mr. Burns wants to open that door, he does so over my objection and with me reserving the right to cross this witness about that evidence and issues that may relate to it.
I'm getting to my main point, Mr. Chairman, and whether I open any doors or not, I guess will be visible after I'm done with my questioning.
Overruled.
I would say, Mr. Chairman, it is already going into an area that I did not discuss with this witness.
Mm-hmm. All right. Objection overruled. Please continue.
Do you see the words reasonably transparent in this testimony, in this section of the statute?
yes.
Section J.
Yeah. Mm-hmm.
Each electrical utility's avoided cost filing must be reasonably transparent. Is that right?
Correct.
Okay. So that underlying assumptions, data, and results can be independently reviewed and verified by the parties and the commission, correct?
Correct.
Was the avoided cost filing made in April by Dominion reasonably transparent so that you, as an opposing expert, could independently review and verify the assumptions, data, and results?
No way.
Okay. What about after the testimony was, after the direct testimony was provided by Dominion in support of its application?
So that would be the testimony in end of June?
Yes, sir.
Yeah. No, I mean, there was more information provided the study was provided, but not all the underlying data and assumptions in the study were provided at that point.
There were also some questions about Mr. David's fourth correction, where he changed his reference from one set of spreadsheets to the spreadsheets in response to CC, but request number 2-14. You remember that?
Yes.
Let me ask you the question this way. Was the problem with what was produced in response to each of those two requests, or how Mr. David referenced it in his testimony?
The problem was not necessarily with the workbook, but with the context was really important there, and the specific reference that he used that was incorrect, and completely changes sort of anyone's interpretation of that testimony because the reference is a different thing.
Mr. Willoughby suggested in his cross-examination to you that you were only making critiques and criticisms of someone else's work. What do you see as your role as an expert for an intervener in this proceeding?
I think there's probably a few different things. One is actually to make critiques as suggested, but another is to conduct, additional analysis, which I did, and, for fairly detailed analysis, I think.
Did you provide any recommendations that, in your opinion, will assist the commission in evaluating the proper level of the VIC in this case, beyond just critiques?
I believe I did.
There was also some question, I think Mr. Willoughby, if I recall correctly, and subject to check, there was a line of questions where Mr. Willoughby said or asked you if what you did was find supposed errors in Guidehouse's methodology, and if you correct enough of them, you get down to a 0 VIC. Is that the essence of your testimony?
Not really. I mean, if there are errors to be corrected, they should be corrected. And if it produces a 0 result, then that's the fact, that's the truth. And I think it also confuses the two, recommendations I provided, because one set of recommendations was to, again, sort of take Dominion at their word that, this study was done in an appropriate way, and then fine tune it a little bit. But the other was to sort of take a step back and look at the fundamental picture of like what's happening on Dominion's system, and ask the question, do we even need incremental reserves in the first place? And that was the basis of the first recommendation for the 0 value.
Thank you, Mr. Burgess. Bear with me just one moment, and I may have completed my questions. By the way, looking back at the statute, it's been looked at several times. Does the requirement in Act 62 for fixed price power purchase agreements, is that consistent with the setting of an interim VIC, in your opinion?
Could you repeat the question?
Is the statutory requirement that each electrical utilities shall offer to enter into fixed price power purchase agreements consistent with an interim VIC, in your opinion?
Not really. I mean, it's not fixed if it's subject to future changes. So I guess it's sort of inconsistent in that sense.
Okay. If Dominion took the recommendations set forth in your analysis, would they be able to maintain reliability on their system?
I believe so.
I think that's all the questions I have at this time. Thank you, Mr. Burgess.
Mr. Chairman, I have a few in response.
Yes, sir. Go ahead.
Mr. Burgess, you just offered an opinion about how a desk can reliably operate its system. Have you ever been in a control room for utility or operated or dispatched electric generating units?
I've been in control rooms, but I haven't myself dispatched or operated them.
And you were there purely as an observer, correct?
Correct.
So you've never been an operator, you've never had the responsibility to reliably dispatch generating units, have you?
I have not.
And wouldn't you know if you were? Take, for example, are you familiar with balancing areas and the requirements that Dominion Energy has to comply with NERC balancing standards?
Yes.
You're generally familiar that that's an important concept, but you really don't know how that operates or works because you never had to dispatch a system, have you?
I haven't, but I've studied a lot of those requirements and analyzed them over the years. So I would say it's not just a passing understanding, but it's I do understand their importance and how they play a role.
So are you familiar with the Control Performance Standard 1? That's generally referred to as compliance requirement of BAL-001-2.
Yeah, that was the one I believe that was in the Guidehouse study that we were discussing about, the 15-minute interval.
And you used it, of course, for your purposes, but are you aware that the Control Performance Standard 1 assigns each balancing area a slice of responsibility for control, in our case, of the eastern interconnection frequency?
Right, that would make sense.
And would it be also true that the Control Performance Standard 1 measures how well a balancing area is supporting frequency on the eastern interconnection, correct?
Yes, that makes sense.
And you would also be aware that the Control Performance Standard 1 takes 1 minute averages to calculate a monthly average. Isn't that correct?
That sounds right to me.
And would you be aware that out of 30 balancing areas in the eastern interconnection, Dominion Energy South Carolina had the third lowest CPS-1 score in March 2021 and the lowest CPS-1 score in April 2021, months that solar makes up the highest percentage of generation on the Dominion Energy South Carolina system.
That would be new information to me. I wasn't provided any of the testimony that I reviewed, and I wouldn't know whether solar was the driving factor behind that or not without some additional information. There could be a lot of reasons why that would occur.
Well, even if we gave you the information, you wouldn't be in a position because of your lack of expertise in operating and dispatching a system to draw a judgment as to whether or not the solar was creating the problem or it was some other issue, would you?
I guess it depends on what information you would be providing.
And I thank you very much, Mr. Burgess. Those are all the questions I have.
All right, Mr.
Mr. Chairman, I have a very brief redirect on the very specific subject Mr. Willoughby just addressed, if you don't mind.
How far is this going to go?
This will be it for me, Mr. Chairman. I don't want to test your patience, but we probably already have.
Oh, I have all the patience in the world, all the time in the world, but it just seems that you guys just keep going like the Energizer Bunny with one more point. I would imagine Attorney Willoughby would have.
I promise you, I stopped beating the drum a long time ago, but I'm trying.
No, I got you.
The only observation I would make, Mr. Chairman, is a additional rebuttal is I don't think authorized or permitted. And I would also suggest that Mr. Burns is probably getting ready to try to lead his witness down some path. I don't know what path yet, but I would object to him being given another bite at the apple.
I understand. Well, look, I know sometimes things are the rules are liberally construed around here, but I think each party has had a fair opportunity. All parties, for that matter,
Thank you, Mr.
have had a
Chair.
fair opportunity to ask questions and raise issues. So I'm going to deny your request, Attorney Burns.
You have been
That's fine.
very
Thank you,
fair,
Mr. Chair.
Mr. Chairman, no question.
All right. Mr. Burgess, you may step down, sir, and you are excused.
Thank you.
Please call your next witness.
Mr. Chairman, members of the commission, I'm Richard Witt for SECIBA. Our last witness is Steve Levitas.
Mr. Levitas, if you would take the witness stand and please pause to be sworn in by the court reporter.
Can you hear me okay, Mr. Chairman?
Loud and clear.
Great.
Would you please raise your right hand? Do you solemnly swear that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Levitas, please state your name and your business address.
My name is Stephen Levitas. My business address is 130 Roberts Street in Asheville, North Carolina, 28801.
By whom were you employed and in what capacity?
I work for Pinegate Renewables, and I'm the Senior Vice President for Regulatory and Government Affairs.
Mr. Levitas, did you cause to be prepared direct testimony consisting of 19 pages?
I did.
Do you have changes or corrections to that testimony?
I don't, Mr. Witt. In my summary, I'm going to touch on one issue that I raised in my testimony that I intend to withdraw as a point of contention, but no other changes.
Okay, thank you. If I ask you the questions in your direct testimony, would your answers be the same?
They would.
Mr. Chairman, I'd like to move Mr. Levitas' direct testimony into the record as if given orally from the stand.
Mr. Levitas's direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Levitas, did you cause to be prepared, sir, rebuttal testimony consisting of 15 pages?
Yes, sir, I did.
Do you have changes or corrections to that, sir, rebuttal testimony?
No, I don't, other than as I just indicated.
Okay. If I ask you the questions in your sir rebuttal testimony today, would your answers be the same?
They would.
Mr. Chairman, I want to move Mr. Levitas' sir rebuttal testimony into the record as if given orally from the stand.
Mr. Levitas's sir rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Levitas, did you prepare or cause to be prepared a sir rebuttal exhibit SJLR1?
Yes, I did.
Do you have any changes to that exhibit?
No, I do not.
Mr. Chairman, I'd like to move Mr. Levitas' sir rebuttal exhibit SJLR-1 into the record.
SJR1 will be marked and entered into the record as hearing exhibit 11.
Thank you, Mr. Chairman. Mr. Levitas, do you have a summary of combined summary of both your direct and sir rebuttal testimony?
I do.
Would you please present your summary?
Yes, sir. Good afternoon, Mr. Chairman and members of the commission. Again, I'm Steve Levitas, Senior Vice President for Regulatory and Government Affairs at Pinegate Renewables. Pinegate is a utility-scale solar and storage developer based in Asheville, North Carolina, with a large portfolio of operating and development solar assets in South Carolina, including 124 megawatts of projects in operation in DESC service territory, another 101 megawatts under construction, again in Dominion territory, and 212 megawatts in development. I'm also a member of the board of directors of Intervenor Carolina's Clean Energy Business Association, or CCBA.
My testimony in this matter addresses DESC's Form Power Purchase Agreement and proposed Notice of Commitment form for PURPA qualifying facilities. In my direct testimony, I identified several proposed PPA terms that are not commercially reasonable. In his rebuttal testimony, witness Cassis suggested that the standard of commercial reasonableness is inappropriate, and he inaccurately claimed that this commission has previously rejected such a standard. In fact, as I explained in my surrebuttal testimony, and as Mr. Cassis acknowledged in his cross-examination, South Carolina law actually requires this commission to determine whether PPA terms are commercially reasonable. Moreover, following that statutory mandate in the last DESC PURPA proceeding, this commission rejected a number of DESC's proposed PPA terms and conditions as not being commercially reasonable. What the commission declined to do, which I take no issue with, is to include a definition of commercial reasonableness in the DESC form PPA as a defined term. In my direct testimony, I addressed 4 aspects of DESC's proposed PPA, which I believe are commercially unreasonable and should not be approved, 3 of which involve modifications to the form PPA previously approved by this commission. First, DESC removed cash collateral as an express option for performance assurance, but that is an important and valuable option for project developers and is industry standard in my experience. Witness Folsom's rebuttal testimony stated that the company has agreed to reinstate that option, and we appreciate it doing so. Second, I addressed 2 problems with DESC's changes to the form of surety bond. First, reducing the pay period from 15 days to 10 days after demand, and second, requiring that a surety waive all rights and defenses, counterclaims, set-offs, cross-claims, and any other claims. Those conditions are unjustified and will likely make surety bonds much more expensive or really, in all likelihood, not available at all. In rebuttal, witness Folsom says the new conditions are justified to ensure that DESC's customers are adequately protected and the DESC's parent company has used them. But Mr. Folsom offered no evidence that the current requirements have not protected customers, and his general statements about DESC's corporate practice don't show that these are commercially reasonable terms in South Carolina, where the prior language has been used now for some years. Third, I proposed changes in the PPA's insurance requirements, specifically new timing for certificate of insurance delivery and revised coverage amounts. And now to the issue that I'm going to withdraw at this time. Having heard witness Folsom's explanation of the timing issue for when an insurance certificate has to be provided, I found that persuasive, and I'm prepared to withdraw my objection to that change. My testimony also objected to increased insurance coverage amounts, which were justified simply as being consistent with Dominion's corporate practice. In rebuttal, witness Folsom offered a new rationale. The increased coverage amounts are needed, he says, due to the use of emergent technologies such as storage. I responded in my surrebuttal by pointing out that the company has not identified a single instance in which QF insurance coverage has been needed to protect DESC and its ratepayers from loss, let alone one where the current coverage levels have proven to be inadequate. While it's true that the addition of storage components to some QF facilities might increase their economic value, that alone is no basis for doubling coverage amounts for personal injury, workers' compensation, and automobile liability insurance. Arbitrary increases in the amount and scope of insurance needlessly increase the cost of QF projects, and the current required coverage levels which you previously approved should be maintained. The last PPA issue I addressed was ancillary services. DESC's PPA defines energy to include ancillary services like reactive power and voltage control, and asserts that these belong to buyer, this is a quote, belong to buyer at no additional cost to buyer beyond the rates paid for avoided energy. I testify that this is not just unreasonable if such services are not included in the calculation of avoided costs and QFs are not otherwise compensated for providing these valuable services. In his rebuttal, witness Cassis confirms at page 11 that ancillary services are not included in the calculation of avoided costs, but then states at page 13 that the form PPA language giving those to DESC, quote, at no additional cost, does not, quote, preclude DESC from negotiating with a QF generator capable of providing such services when DSC needs them. The end result runs afoul of Act 62, which requires that the commission treat small power producers on a, quote, fair and equal footing with electrical utility-owned resources, close quote, by ensuring that avoided cost rates fully reflect the utility's included costs with a methodology that fairly accounts for costs avoided, quote, including ancillary services provided by or consumed by small power producers, including those utilizing energy storage equipment. At a minimum, the commission should require DSC to remove the language in the PPA purporting to give DESC ancillary services for free. My testimony addressed three aspects of DSC's proposed NOC form. First, DSC proposes to modify the form to require that the QF has either commenced construction or taken meaningful steps to obtain control of the project site, quote, in order to commence construction of the facility. DSC responded to my testimony by saying that its proposed language did not require commencement of construction, only that the seller take meaningful steps to obtain control such that it could commence construction. That was from witness Folsom's rebuttal. To clarify its intent, DSC has proposed to alter the proposed language to say that a QF must have taken meaningful steps to obtain site control, quote, adequate to commence construction, rather than in order to commence construction. Unfortunately, this doesn't solve the problem. Site control adequate to commence construction could be read to require outright ownership or fully executed leasehold interest of land in order to form a LEO. By contrast, under the current NOC form, an option to exercise such property interests can suffice to show sufficient site control for a LEO. Recognition that a developer faces considerable project risk prior to entering into the interconnection study process. Although FERC may have authorized a reference to commencement of construction in in Order 872, with which I'm quite familiar, it does not require it. It leaves that decision to you as a state commission, subject to Act 62. And I can see no reason to mention commencement of construction at all in connection with the site control requirement. The second NOC item addresses DSC's proposed requirement that the QF prove it has submitted the applications and filing fees necessary to secure, quote, all local permitting and zoning approvals, close quote, for the site, and then another quote, necessary to operate and maintain the facility for the delivery term. I testified that many local permits, such as electrical permits, building permits, and stormwater plan approvals, are not typically applied for until close to the time the construction actually commences. Witness Folsom's primary response, again referencing Order 872, is that FERC has authorized the states to require that all permits be made as a condition of LEO formation. That's true. That language does appear in Order 872, but again, it is authorizing, not mandatory. FERC has left it to you as this commission to decide what is reasonable and appropriate for the state of South Carolina, particularly in light of the intent of the General Assembly as expressed in Act 62. That does not mean, so the FERC language does not mean that the commission should adopt the change. We're doing so would frustrate QF development and the clear legislative intent of Act 62 to promote QF development. Preventing LEO formation and denying QF developers price certainty until the very end of the development cycle would make it virtually impossible to incur the substantial development costs required to bring a QF to the point of commencing construction. In his rebuttal testimony, witness Folsom offered new language that would require the project developer to prove it has submitted the applications and filing fees necessary to secure local permitting and zoning approvals for the site, quote, necessary to commence construction of the facility rather than necessary to operate and maintain it. However, that proposed revision does nothing to address the problem I just identified in my testimony. A developer is unlikely to be able to apply for construction-related permits, which require engineered site layout plans until shortly before construction commences. The third item I addressed in DSC's proposed NOC form change was language providing that the NOC would terminate if the seller had not executed a PPA within 90 days of the NOC submittal. I'll just move through this quickly because the company has agreed to the language that I proposed to address this issue. It's now contained in the proposed NOC form attached to witness Folsom's rebuttal testimony. And again, we appreciate DESC's responsiveness on that issue as well. Finally, beyond the NOC and PPA forms, my testimony emphasizes the very significant commercial problems raised by a variable integration charge that can be retroactively changed even after a PPA has been executed and a project has been built. In response, witness Cassis asserts that because most of the projects with VIC language in their PPAs have reached commercial operation, a variable VIC is not commercially problematic. However, prior to this commission's orders in docket number 2019-184E, DESC and its predecessors, SCG, had never been authorized by this commission to impose a VIC on QFs, and it had not done so. Yet it entered into a number of PPAs that provided that a VIC subsequently approved by the commission would be incorporated into the PPA. I don't disagree that developers were able to finance and construct QFs, notwithstanding this uncertainty, and I think in most cases at a higher PPA price than what exists today. But because it was actually before the commission decided to authorize the VIC and before DESC began proposing very high VICs in these dockets, you can't really compare that to the current situation. Since those two events occurred, the risk proposition for developers and their financing parties has changed dramatically. The more relevant benchmark is how many QF PPAs have been executed and how many projects have been financed and placed in service since an indeterminate VIC has been included in avoided cost rates. Mr. Cassis has acknowledged that the answer to that question appears to be zero. In my rebuttal testimony, I also point out that the variable integration charge that is not fixed for the life of the PPA, but is subject to adjustment and true-up also raises legal issues. Section 58-41-20F1 of the South Carolina Code of Laws provides that, quote, electrical utilities subject to approval of the commission shall offer to enter into fixed price power purchase agreements with small power producers for the purchase of energy and capacity at avoided costs. In adopting this commission, the General Assembly recognized that certainty regarding contracted cash flows is essential to promoting QF development. Contrary to this statutory mandate, DESC's PPAs that include either a VIC or an avoided cost rate that is subject to modification and true-up based on future analysis and regulatory proceedings is not a fixed PPA. My testimony recommends that the commission either eliminate the VIC altogether or adopt a reasonable level of variable integration costs that is fixed for the current term of all existing PPAs subject to the VIC or entered into prior to any adjustment in DESC's variable integration costs by this commission. Notably, this is exactly the approach taken by Duke Energy and approved by both this commission and its North Carolina counterpart. In both states, the avoided cost rate paid by Duke to QF developers includes a fixed reduction for variable integration costs based on what was deemed to be a reasonable, if imperfect, estimate of such costs at the time. Those developers will be subject to any modifications in variable integration costs in effect at the time they renew their PPAs. This concludes my summary.
Thank you, Mr. Levitas. Mr. Chairman, Mr. Levitas is available for questions. Thank you.
All right, any questions from the interveners? All right, hearing none. Applicant?
Thank you, Mr. Chairman. Good afternoon, Mr. Levitas. My name is Chad Burgess. I'm in-house corporate counsel for Dominion Energy, South Carolina, and it's nice to see you today. Can you hear me all right?
Loud and clear. Nice to see you, Mr. Burgess.
Great, thank you. Mr. Levitas, I've just got a few questions about your testimony that you presented to the commission here today. And I want to make sure I've got everything situated and correct in my mind, but I thought I heard you say that you are a Pine Gates Renewables employee. Is that correct?
That is correct.
And Pine Gate Renewables is in fact a party in this proceeding. Is that correct?
That's correct.
But you're not testifying on behalf of Pine Gate Renewables here today, are you?
No,
Indeed, I believe you're testifying on behalf of the Carolinas Clean Energy Business Association, known as CCEBA. Is that correct?
yes, sir.
All right. So you work for Pine Gate Renewables Energy. Pine Gate Renewable Energy is a party to this proceeding, but Pine Gate Renewables elected not to present you as a witness on its behalf. Do I have that right?
Well, I think you'll have to talk to Pine Gate Council, Mr. Holman, about what may be the rationale for why I'm appearing for one intervener rather than the other. But I am a member of the board, as I mentioned, of CCEBA, and have testified before this commission on numerous occasions on behalf of CCEBA and its predecessor.
Sure. I'm not sure Mr. Burns is a witness to this proceeding, Mr. Levitas, so I'd actually like to hear from you as to why you are not testifying on behalf of Pine Gate Renewables today.
Well, I don't think there was any intention on the part of Pine Gate not to associate itself with my testimony. I really, again, I'd have to look to, I'm not a practicing lawyer before this commission, and so I'm not sure exactly what the procedural considerations were. I don't think there was any intention for Pine Gate not to be associated with my testimony. I'm not sure if I was able to testify for both parties. Perhaps we could have set it up that way. But I think the main intent, as I understood it, was to make clear that I was offering opinions on behalf of the industry as a whole through our trade association.
But your own employer decided not to present you as a witness on its behalf in this proceeding, correct?
Mr. Chairman, this is Bland Holman for Pine Gate. If Mr. Burgess has some questions about what Pine Gate decided to do, he can ask them to me. Mr. Burgess, you just heard, let me finish, please. You just heard Mr. Levitas say he's testifying on behalf of CCEBA, and that's an industry-wide organization. The fact that he's also an employee of Pine Gate doesn't mean that he can't do that unless you have some basis for saying so.
Mr. Chairman, with all due respect, I'm not going to ask Mr. Holman any questions in this proceeding. He represents Pine Gate Renewables, who's a party to this proceeding, so I would decline his request to do that. I would like to ask the witness who's on the stand right now.
Mr. Chairman, this is Richard Witt.
Mr. Witt, would you mind if I was able just to finish my response?
My objections for your prior two questions. So, Mr. Chairman, may I be heard?
No, not at this moment. And let me say this. I feel as if the lawyers up until this point have done a very good job of being respectful toward one another. I don't know if it's because it's late in the evening or Monday, but we seem to have some, I don't know what's going on. But what I would ask is that the lawyers maintain their level of professionalism that they demonstrated throughout this proceeding. If you have an objection, raise it, state the objection, and allow the opportunity for opposing counsel to respond. If there are issues, well, I'll just say that. So, Attorney Burgess, if you would please finish your response to. Well, I don't know if I'm confused. What's going on right now? Did someone make an objection?
Mr. Chairman, this is Richard Witt for CCEBA. I made an objection.
Right, but that came during Attorney Burgess's response to Attorney Hallman. So let's get this train back on the tracks. So,
Mr. Chairman, this is Chad Burgess, and that's precisely what I was trying to do. And I think Mr. Holman's interjection has precisely done what I thought they were doing. Mr. Holman doesn't represent Sasiba. He represents Pine Gate Renewables. Mr. Levitas is a witness by his own direct testimony on behalf of Sasiba. I'm just simply wanting to understand and make clear for the record that Mr. Levitas's own employer chose not to present him as a witness in this proceedings. I'm entitled to ask him that question. And it was a simple question to make sure I had it all the facts right in my mind. Mr. Levitas went down with his response with, I'm not a lawyer who practiced before this commission. You need to ask Mr. Burns. And then Mr. Holman turned on his video camera and interjected himself into the dialogue.
Right, which was improper. So, got that. The witness is Attorney Witt's witness, correct? He put him up for
That's
the record.
correct, Mr. Chairman.
All right, Attorney Witt, you have an objection.
Yes, Mr. Chairman, thank you. I mean, he asked the question twice, and Mr. Levitas gave a pretty comprehensive answer twice. I don't know why we need to continue on this, or what the relevance would be of asking it 3 times.
Well, Mr. Chairman, I'm just trying to make sure I've got everything right in my mind. And for the commission, I didn't hear Mr. Levitas answer my question, which is why I repeated it. So I would just simply want to make sure I understand why Pine Gate Renewables didn't put its own employee up as a witness in this proceeding and chose to proceed in the manner in which they did. It should be a simple answer to a simple question.
All right.
I'm sorry that it has evolved to a great debate.
All right, got it. So you did ask the question several times. There were some interruptions. I'm going to ask you to ask the question again, accept the answer, and move on.
Thank you, Mr. Chairman. So, Mr. Levitas, you are a Pine Gate Pine Gate Renewables employee. Pine Gate Renewables is a party to this proceeding, but yet you are not testifying on behalf of your employer, Pine Gate Renewables, in this proceeding. Do I have that correct?
Yes, my understanding, Mr. Burgess, is that the decision made by the lawyers for interveners, the strategic decision, was that it was important to make the point that I was going to provide testimony on behalf of the entire industry trade association, as I've done on multiple occasions, and that it was not the testimony of a single company. It was not intended to reflect any disavowal or distancing from my testimony on the part of Pine Gate Renewables. I'm sure that if you would like a stipulation from Pine Gate that it fully embraces and adopts my testimony and agrees with it, we can provide that. But as I told you, the reason for it was not a sort of negative reason, as you're implying, but to make clear that I am speaking on behalf of the Industry Trade Association, not on behalf of one company.
Okay. Thank you very much, Mr. Levitas. So Pine Gate Renewables is a member of Sasiba, is it not?
That's correct.
And I think I heard you testify earlier that Pine Gate Renewables holds membership on Sasiba's executive committee of its board of directors, correct?
I mentioned the board, but it's also on the executive committee.
Okay. And that person who actually sits on the board is you, correct?
That's correct.
Okay. Is it fair for me to conclude that Sasiba adequately represents the interest of Pine Gate Renewables?
Well, on most issues, on many issues, this would not be the first time that Pine Gate or other individual members of CCBA or other trade associations of which we're members have appeared in proceedings both through the trade association and in their independent capacity where it might prove to be necessary to represent the interests of the company independently.
So, yeah, I understand your answer to be that Sasiba does in fact adequately represent the interests of Pine Gate Renewables.
I'm not aware of any issue in this proceeding in which CCBA does not adequately represent the interests of Pine Gate Renewables.
All right. How about Johnson Developments? The Johnson Development Association, they are in fact a member of Sasiba too, correct?
I'm not certain about that. I think they have been in the past. I don't recall regularly interacting with a representative of Johnson Development. I don't have a full member roster. I think they may be, they are members, but not one that I have regular contact with in my capacities.
But you said you think they are members of SECIBA, correct?
I think they may be, yes.
And is it fair to say that SECIBA adequately represents the interests of Johnson Development Associates?
I can't speak for Johnson Development.
But you can't speak for the members of SECIBA, correct?
In what regard?
In regard to your testimony.
Yeah, you asked if SECIBA adequately represented the interest of Johnson Development, and I said I don't know the answer to that question. I can't.
That's right. And I followed that.
Is your question, do I think that SECIBA adequately represents the interests of its members?
Yes, I'm not trying to trick you, Mr. Levitas. I really am not. It's a simple question. Does SECIBA adequately represent the interests of its members, which would include Pine Gate Renewables and Johnson Development?
I think SECIBA does an outstanding job representing the interests of its members. It's a diverse membership. From time to time, there are differences of opinion within the membership about a variety of issues. And in some cases, those members pursue independent representation if they perceive that the organization it's not so much an issue of adequate representation. There may be a difference of opinion between an individual member and the position of the trade association.
And for this proceeding, SECIBA is really just the alter ego of Pine Gate Renewables, Johnson Development Associates, and its other members, correct?
Mr. Chairman, Richard Witt, have you heard?
Yes, sir.
I object to this, which has gone on for quite a while, for relevance now, Mr. Chairman.
Sustain.
So, Mr. Levitas, on page 4, line 10 of your server rebuttal testimony, you characterize yourself as an expert witness. So you don't, as an expert witness, you don't need to rely on others to help you write your testimony, do you?
Not any more than any other expert witness.
Okay. And nobody's required to approve the accuracy of your statements in your testimony, are they?
No.
And you don't write by committee, do you?
No.
Okay. Now on page 2, line 22, through page 3, line 2 of your server rebuttal testimony, you state, the issues on which I testified in this proceeding, like the ones I addressed in the proceeding DESC docket 2019-184E, directly impacts the interest of independent clean energy businesses that comprise the SECIBA membership, including Pine Gate Renewables. You testified to that, right?
That sounds right. I don't have it in front of me.
Okay. Would you like for me to show it to you?
I'll take your word for it. It sounds right.
But isn't it correct, Mr. Levitas, you just don't mention issues in your testimony. You actually instead testified on the measures that SECIBA is unwilling to accept, and you actually offer other specific changes that SECIBA would accept, correct?
I'm not sure I understand your distinction in choice of words. There are issues in this proceeding that will involve form documents, terms and conditions in form documents. Those are the matters that I have testified about.
Okay.
And those issues or something else.
And those things that you testified about, those are actual changes that you would like to see made in the documents that DESC has presented to this commission for approval, correct?
That's right. The changes based on my judgment and expert opinion about what constitutes commercially reasonable transaction documents for PURPA QFs.
And there was no stakeholder process to determine the changes and the specific changes that are provided in your testimony, was it?
I'm not aware of any stakeholder process, no.
Okay, was there a vote among the SECIBA members when it came to the changes that you presented in your testimonies?
No, there was not.
So, Mr. Levitas, how would you ensure that there are no other issues that members have related to your testimonies?
Well, first of all, as an expert on these matters, the organization has historically relied on my judgment to a large extent as to the appropriate issues to raise. So that primarily informs my testimony. In the course of, I don't remember specific conversations in this instance, but in the course of many years of working on these PURPA documents, not only in South Carolina, but in other jurisdictions and at FERC, I have had many conversations with other folks in the industry about these kinds of issues. So, I've previously said that I think in the prior proceeding that I think commercial reasonableness is informed in part by market experience. So I've certainly had conversations over the years with other parties about these types of issues, but what's reflected in my testimony is my personal opinion about what is commercially reasonable.
That's right, your personal opinion, Mr. Levitas. So you can't be certain that there's complete agreement within SECIVA's membership with respect to the issues and recommendations that you've laid out in your testimony, can you?
Mr. Chairman, Richard Witt again, I apologize, but if I may be heard.
Yes, sir.
Mr. Chairman, I apologize for interrupting again, and with all due respect to Mr. Burgess, there's two straight questions on the internal workings of SECIVA, and Mr. Levitas filed direct and servable testimony. He's accepted as knowledgeable in this area, and I object to questions about the inner workings of SECIVA. I just think it's irrelevant.
Mr. Chairman, I don't think the inner workings of SECIVA are irrelevant. This SECIVA intervened in this proceeding. Mr. Levitas is testifying on behalf of SECIVA. I'm perfectly entitled under due process to ask about the organization by which he's representing and appearing on behalf of today. So I do believe that Mr. Levitas has answered all the questions to my satisfaction, maybe not to others, but I'm ready to move on if that's all right with you, Mr. Chairman.
Absolutely. If you're ready to move on, please move on.
All right. Mr. Levitas, I want to refer you to page 7 of your direct testimony. Do you have that in front of you?
I don't. I apologize, Mr. Burgess.
There's no need to apologize, Mr. Levitas. I have come prepared if you don't have it. So no worries. Let me see if I can pull it up here real quick. Just give me 1 second, Mr. Levitas. I had a lot of documents open here. Okay, let me expand this a little bit here. And Mr. Levitas, this is, can you see the screen okay? It says the direct testimony of Stephen J. Levitas. That's you, right?
Right, I can see that very well.
Okay, great. Sorry for the scrolling here. So I wanted to direct your attention to page 7. And right here at line 7, are you with me?
Hey, I must apologize. I was trying to turn off my phone.
Oh, that's if you need to take that call, go right ahead.
That's all right. Thank you.
Okay. All right. Line 7. I believe that both PURPA and Act 62 require this commission to approve contract and knock terms and conditions that strike a reasonable balance between the legitimate interest of the QF and those of the utility in light of generally prevailing practice in the industry. Did I quote your testimony correctly?
You're a good reader.
Okay, I assume that's a yes. So in your direct testimony, Mr. Levitas, you did not take into account the interest of customers, Dominion Energy's customers, did you?
Well, the reference to utility, and that's probably a inadvertent error or shorthand on my part. I've been a little hasty there. Whenever in the context of PURPA, we think about this balance, and it typically is a balance and a struggle, if you will, in these proceedings. The utility is acting typically with respect to ratepayer interests with respect to these matters. And so it's certainly my intention there to refer to the interests of ratepayers.
Okay.
I often use the phrase the utility and its ratepayers in that context, and that's an oversight not to have included it there.
So I want to make sure I understand your testimony, Mr. Levitas. So I thought I heard you say that Dominion Energy is in fact representing the interests of its ratepayers in this proceeding, correct?
I did say that there are interests that the utility has in the context of PURPA implementation that are independent from those of its ratepayers, but certainly many aspects of the utility's position in these proceedings is relevant to ratepayer interests. And we recognize that and try to strike a reasonable balance.
All right, thank you for that, Mr. Levitas. And I want to draw your attention to another document here. We've seen this in this proceeding, but it bears repeating because it is important. So I'm going to share my screen one more time with you. Okay, I'm going to get you to focus on it's on my left. I hope it's on your left too, Mr. Levitas, where it says any decision by the commission shall be, and then there's a bulleted items. And this is South Carolina Code Section 5841-20-A, which is Act 62, which you're familiar with Act 62, correct?
Yes, sir. I helped write it.
Oh, very good. Okay. All right. So, Mr. Levitas, this says that any decisions by the commission shall be, one, just and reasonable to the ratepayers of the electrical utility, correct?
Yes.
In the public interest, correct?
Yes.
Consistent with PURPA and FERC implementing regulations order, correct?
Yes.
And you would agree with me that those three items are focused on customers, correct?
And the first two, yes. The third one, in referencing PURPA and the Federal Energy Commission's implementing regulations, goes to my point about the balancing of those ratepayer and QF interests.
So is it your testimony that bullet 3 there is not designed to protect customers?
It's designed to achieve a reasonable balance between customer interest and QF development, which is the goal of PURPA and Act 62.
And that reasonable balance would be to ensure that customers don't pay more for the actual avoided costs that are being avoided, correct?
That is certainly a central element of PURPA.
And this last bullet down here, Mr. Levitas, shall strive to reduce the risk placed on the using and consuming public. That's another protection for customers, correct?
That's correct.
Stop sharing my screen, Mr. Levitas. Okay, now, Mr. Levitas, you are aware that the commission has approved the DESC form PPA 2 years ago in docket 2019-184-E, correct?
Yes, I was a witness in that proceeding.
And you're also aware that in section 3.5 of the form PPA that the commission approved, there are provisions related to the performance related to performance liquidated damages, correct?
And I don't have the PPA in front of me, but I'm aware that there are performance liquidated damages in the PPA.
Okay, and isn't it correct that those provisions require QF to pay liquidated damages to DESC if the QF does not meet its guaranteed energy production? Isn't that right?
As that term is defined, it's not 100% requirement, as I recall.
Right, but they are required to pay some sort of damages for not actually providing the power that they promised to produce, correct?
That's correct.
Okay. And isn't it true that Pine Gate Renewables owns a solar QF called Peony Solar?
That's correct, yeah.
Okay. And PE Solar executed a PPA with that same guaranteed energy production obligation, did it not?
Yes, it did.
And isn't it true, Mr. Levitas, that those provisions in these PPAs are meant to protect consumers in the event that the QF does not meet its obligations under the PPA, correct?
Are you referring to the liquidated damages provisions?
That's right. That would be a measure to protect customers, correct?
I'm not entirely certain about the purpose and effect of those provisions. And they're a liquidated damages provision. I'm not sure to what extent they actually are needed to protect customers, but I'll accept for the purposes of your question that that is the perspective of the company as to the purpose of those provisions.
You would agree with me, would you not, Mr. Levitas, that customers, they're the ones who pay for the avoided costs that are being paid under a PPA, correct?
That's right. In the case of, my point is, in the case of liquidated damages, as opposed to actual damages, those damages are paid regardless of whether there are any actual damages that are incurred, including any damage to the customer.
And you understand that if a QF doesn't perform under the contract that they have promised to perform under, that's when that provision would kick in. You understand that, don't you, Mr. Levitas?
I do.
And that provision is to ensure that customers are protected from what they're paying for, correct, Mr. Levitas?
Well, I already answered that question. It's unclear to me in the case of liquidated damages what they actually accomplish and the extent to which they're necessary, but they're in there and we have to pay them.
All right, very good. And those damages, now you understand, well, let me ask it this way. Isn't it true that DESC has demanded payment from PE Solar under the commission approved performance liquidated damages provisions in its PPA, correct?
That's correct, yeah.
Okay. And those damages are owed to DESC because PE Solar was unable to meet the minimum level of energy production that it promised DESC that it would provide, correct?
No, so there have been a couple of years, I think now the second year, where an issue of liquidated damages have come up with respect to P&E. I'm not sure what this has to do with this proceeding, but I'm happy to talk about it. There have in both cases been disputes about the cause of reduced output at the P&E facility. And I'm not sure I'm at liberty to talk about the resolution of the prior year claim by DESC, but it was successfully resolved. And there is a pending claim with respect to the subsequent year that is still under discussion.
That's right. There's a pending claim because PE Solar has not yet paid the money that's owed to DESC for failing to perform under the contract.
Mr. Chairman, Richard Witt for SECEBA.
Yes, sir.
Object to, I mean, we've gone on for a while already on this subject, but I object to a specific project that Attorney Burgess is asking about. Now he's getting in areas of that the witnesses indicated may be confidential. And now he's asking what the resolution will be and saying something is past due. I just think it's irrelevant and we object to it.
Mr. Chairman, I have not asked Mr. Levitas to disclose any confidential information. And if any of my answers, or excuse me, if any of my questions do elicit confidential information, I would expect Mr. Levitas to say so. He hasn't done that yet. He said he was happy to talk about this. So I think it's perfectly acceptable for me to continue with my line of questioning.
Attorney Burgess, what's the relevance of this line of questioning?
The relevance of this line of question is leading up to the surety bond, which is an issue with respect that Mr. Levitas has taken in his direct testimony. So I'd like to lay some foundation to actually get to that point. And the foundation is that the provision in the surety bond is designed to protect customers. Liquidated damages are designed to protect customers, yet even with liquidated damages in the PPA, QS still fight when DESC's trying to enforce provisions to protect customers. That's the point I'm trying to make here leading up to the surety bond.
All right. Well, if you would just get there, I think we could.
I know it's late, Mr. Chairman. And I apologize for that. I'll do my best. Okay, Mr. Levitas. So as I understand this correctly, not only have you ignored DESC's customers in your commercial reasonable standard by which you judge these PPAs in this proceeding, but you've also shown a disregard for customers when operating under such contracts, correct?
Mr. Burgess, with all due respect, that's an inappropriate question. First of all, I didn't say, in fact, I specifically took issue with you that it was an inadvertent shorthand in the language that you're referring to. And I indicated to you that I do recognize the interests of customers in these conversations. Okay, that's the first thing. And secondly, with respect to the peony matter, I'm surprised by your characterization of it. The first matter from the first issue from last year was a legitimate business dispute or disagreement about the cause of certain actions of the facility that was amicably resolved with your client. Very amicably resolved. No litigation, no need to call upon a surety bond. We paid the money that we agreed to pay after an amicable conversation. We're not avoiding, in the second case, those conversations are ongoing. They've been a little delayed. I think I had an interchange with Mr. Cassis in the last, I can't remember how recently it was, and we need to get back to this and figure out what to do about the puny liquidated damages. So the picture that you're painting is just totally inaccurate.
Mr. Lewis, I know you take issue with DESC's proposed surety bond. Do you understand that DESC's proposed changes in its surety bond to prevent third-party bond issuers from not paying its obligation is designed to protect customers? Do you understand that?
I understand that you would like to your client would like to strike a balance in such a way that every time it asserts a claim, it gets automatic payment and deprives the other party of having any opportunity to assert that your client is in the wrong and that there in fact has not been a breach or a cause giving rise to an obligation to make payment. That's what you would like. Yeah, if customers could absolutely have sort of no questions asked, they get paid no matter what, even when they're not entitled to get paid, that would be a great deal, but it's not a reasonable deal.
Mr. Levis, I'm going to move on to FERC Order 872. You're familiar with that order, are you not?
I am. It's a very long order that I haven't looked at in a little while, but I've read it several times in the past.
Okay, very good. So you mentioned in your server rebuttal testimony, actually in DESC's prior avoided costs, that was the 2019 docket, that you endeavored to give reasoned explanations and suggest measure changes based upon your extensive commercial experience. Do I have that correct?
I'm sorry, could you repeat that? I'm not sure what you were referring to.
Sure. Let me pull up your direct testimony from the 2019 docket here. All right, I'm going to enlarge the size, Mr. Levitas. So this is your server rebuttal testimony from October of 2019. Do you remember that?
I remember providing that testimony. I have not looked at it since that proceeding concluded.
Okay, all right, no problem. I'm going to scroll down here to page 4. Okay, so on page 4 here at the sentence starts at line 16, where I have objected to DESC's terms and conditions. It is because I do not believe they strike this reasonable balance and thus are not commercially reasonable. Does that refresh your memory as to what you said, what you testified to in 2019?
Yes, and if you look back up at line 14, you'll see that in that testimony, I was more careful in my choice of words and referred to the protection of ratepayer interests, not those of the utility.
Okay, very good. Thank you, Mr. Lopez. Okay, and also, Mr. Lopez, isn't it true in that 2019 docket that you also provided server rebuttal testimony regarding the FERC Notice of Proposed Rulemaking, or NOPR, that was issued by the FERC in September of 2019? Is that correct?
That seems right. Again, it's been a couple of years, but that
You're
would make
familiar
sense.
You are familiar with the NOPR that I'm talking about, correct?
The NOPR is what led to Order 872.
That's right. That's exactly right. In fact, FERC issued a final order 872 on that NOPR, did it not?
They did, followed by a subsequent order on rehearing called Order 872-A.
Sure. And have you discussed Order 872 with any FERC commissioner?
Have I discussed Order 872 since it was issued with the FERC commissioner?
Sure.
No, I'm actively involved in the Solar Energy Industries Association PURPA committee, which oversees or directs, I guess you would say, the appeal that SEIA has taken to Order 872 and 872A. So that is an ongoing legal proceeding that we're not able to discuss with FERC commissioners.
Okay, so it's your testimony that you have not discussed FERC Order 872 with any commissioner. I understand you correctly?
With the FERC commissioner?
Yes. Have you discussed Order 872 with any FERC commissioner?
Not in any substantive way. There may have, I really don't recall, but there may have been a procedural conversation about the appeal and the timing of the appeal and that sort of thing, but most of that is left to the SEIA lawyers.
Okay, so just so I'm clear, you have not talked with any FERC commissioner substantively about 872?
Correct.
Okay, thank you, Mr. Levitas. I'm going to share my screen again with you, Mr. Levitas, and I'm going to pull up your server rebuttal testimony that you have filed in this docket. Do you have that server rebuttal testimony with you?
Again, I don't, and this is my technological, I have it. I just was trying not to split my screen so that I could give you my full attention.
Okay, well, I very much appreciate you giving me your full attention. I'll share my screen with you and we can look at it together. Okay, Mr. Levitas, do you see my screen now? I might need to make it a little bit bigger. Okay. Okay, so this is the server rebuttal testimony that you have filed in this docket. And I'm going to scroll down here to page 10. I'll try not to make everybody dizzy here. Okay, so on line 11 here, which starts with the word as, you say, as an aside, I doubt that FERC had in mind these types of permits that can only be secured on the eve of construction. Now, you just told me that you have not spoken with any FERC commissioner substantively about 872. So you really don't know what FERC may or may not have had in its mind with respect to 872, do you, Mr. Levitas?
No, I don't. The basis for that statement is, as I said, I think in the next sentence, that, and looking at Order 872 as a whole, that it would not be consistent, in my mind, with the thrust of Order 872 to say, for FERC to have intended that a LEO could only be formed 2 weeks before construction was about to begin. That does not jibe with the thrust of the order as a whole. So that was the basis for that statement.
And I want to share my screen again with you, Mr. Levitas. I'm going to go back to your 2019 testimony. Give me 1 second here. This is your 2019 server rebuttal testimony. Share my screen here again. And you see that 2019-184 server rebuttal testimonies. Okay. All right, now I'm just going to scroll down here to page 2. section. Yeah, I'm sorry, it's actually, this is page 3, and on line, here it is on line 5. You state, I have substantial concerns about the legality of the proposed rule and the factual support behind it. And then I think you go on to in your testimony and you state that it's going to be anybody's guess whether the NOPR will ever become a proposed rule. Do you remember that?
Yes, sir.
Okay. But you would agree with me, would you not, Mr. Levitas, that many of the reforms in the NOPR were actually included in FERC's final rule via Order 872, correct?
Correct.
So isn't it true, Mr. Levitas, that although you cite your extensive commercial experience in your server rebuttal testimony, you were incorrect with your prediction about the FERC NOPR, were you not?
I wasn't predicting one way or the other. The point of my testimony in the prior proceeding was that the company was seeking to rely on certain proposals that at that time were just that they were proposals. And my position was that it was premature to rely on a proposal until it was determined exactly what FERC would do. And by the way, the orders 872 and 872A, as I mentioned, are on appeal. And so it continues to be uncertain what the ultimate fate of some of these provisions will be.
But you would agree with, would you not, that they may ultimately be upheld on appeal?
They could be.
Okay, I'm going to shift gears on you, Mr. Levitas, and talk with you about the NOP form that you take issue with in this proceeding. You are, I think you said you're an author of Act 62, if I heard you correctly earlier. And Act 62 refers to a notice of commitment to sell form, correct?
Correct.
And Act 62 does not call it a notice of commitment for project design, does it?
No.
And you object to DESC requiring in its NOC form that the QF represent that it has secured or has submitted all applications and filing fees necessary to secure all local permitting and zoning approvals for the project site necessary to commence construction facilities. That's correct, right?
That's right. I objected to the requirement, do object to the requirement that the scope of that be so broad as to include permits that are typically not applied for until very shortly before the commencement of construction. And I think there is some precedent in other PPAs, perhaps even in this state, for that distinction between permits that it's reasonable to expect the QF developer to get early on or to seek early on as a demonstration of its seriousness about the project, and those that no one can possibly get until the very end of the process.
But you did acknowledge in your servable testimony, Mr. Levitas, that the FERC has in fact authorized states to require that the QF show that it has submitted all applications, including filing fees, to obtain all necessary local permitting and zoning approvals in order 872, correct?
What FERC did in Order 872, as I think I mentioned in my summary and in my testimony, is to give, consistent with the cooperative federalism of PURPA, to leave to the states the decision about what these requirements should be. FERC indicated in Order 872 and 872A some things that the state could do and some things that the state could not do, but subject to those limitations, it is up to the state commission and state legislatures to decide what they think is appropriate as to establish as reasonable indicia of the QF's commitment to sell, its commercial viability, and its financing commitment with the terms used by FERC. And my point again is that, in my opinion, a requirement that a permit be applied for, that is only typically applied for a few weeks before construction, is not a reasonable indication of either commercial viability, financial commitment, or a commitment to sell.
And I understand your position, Mr. Levitas, but FERC certainly was pretty clear with the commission that it could in fact require that, right?
The commission could do that if, consistent with FERC guidance. Whether it could do it consistent with Act 62, maybe is less certain, but you're right. The commission can do it. My position is that the commission should not do it, that it would be unreasonable for the commission to impose that requirement.
Right. And you understand, do you not, that purpose section 210A requires that FERC prescribe rules that it deems necessary to encourage the development of qualifying small power production facilities and cogeneration facilities, correct?
That's correct. And that's why many parties have appealed Order 872, specifically on the grounds that those rules, the order and the requirements to abrogate FERC's obligation to adopt rules that encourage QF development.
Right. And back in 2019, you recommended this commission that it give no weight to the NOPR that was pending at the time, correct?
That's right. It was a proposed rule.
That's right. And isn't it true that in this proceeding, you are recommending to the commission again to disregard the FERC's guidance in Order 8 number 72 with respect to DESC's proposed changes to the NOC form?
No, that's not correct. I'm recommending that this commission act consistently with the current FERC order and rules and exercise its discretion and authority to do what it thinks is reasonable.
And FERC says it's reasonable for commissions to require, if they so choose, that QFs to demonstrate site control produce all submitted applications and filing fees necessary for local permitting and zoning approvals, correct?
As I said, Order 872 says that. I hope that in resolving this issue, the commission will look at Order 872 in its entirety. As I said, I think when you look at the order in its entirety, it would be hard to conclude that that FERC intended for state commissions to make a condition of LEO formation having applied for a permit that is typically not applied for until 2 weeks before construction begins.
Now, Mr. Levitas, remind me, how long have you been involved in the solar power industry?
A little over 10 years, 10, 11 years.
And as part of your involvement, you've had conversations with venture capitalists who back solar projects, is that correct?
Well, venture capitalist is a very kind of specific term in the financing world. I think it might be more accurate to say financing parties. Although that, to be clear, that is not my primary role at Pine Gate Renewables to interact with financing parties, but I have certainly had conversations with financing parties.
Okay, is it within your purview at Pine Gate Renewables to have a general understanding of the rate of return that a financing party would find acceptable to finance a project?
I don't know that it's part of my job description, but having been in the solar industry for some time, I certainly have some familiarity with those issues.
Is it fair to say that financing parties seek a 30% return on their investment when backing solar projects?
No, that wouldn't be accurate at all. I'm not sure where you're getting that number. And I think with all due respect, it would require something of a tutorial on solar project finance to really do justice to your question. And I'm happy to go into some of that if you like, or if that's more than you want to bite off, then we can move on.
Well, given some of the chairman's comments earlier today, I don't think we need to go down that path. I'll just simply ask you this. What is the average rate of return that a financing party finds acceptable when working with a solar project?
Well, the reason I said it would require a tutorial or a longer answer is because there are multiple stages of financing in connection with solar project development that have different risk profiles and different required rates of return in order to support that risk. You have early stage development projects where there's the greatest risk of whether a project is going to come into being. With later stage development activities prior to construction, you have investors and financing parties associated with the construction of the facility itself. And then what you sort of seem to be thinking of, parties who invest equity as well as tax equity, but I think what you're interested in is sponsor equity. Maybe you're interested in debt financing as well for the long-term ownership of the asset. And sometimes there's one party that is involved in all of those activities and they roll up in some way to one number. In many cases, there are multiple and different financing parties through that value chain with different rates of return. But I'm not honestly aware of a 30% hurdle at any stage of that process, and certainly not collectively.
How about 20%?
That's not a number. I mean, first of all, let me just say that the rate of return on solar projects varies dramatically, and projects get and across the country with different contract rates and different construction costs, different interconnection costs, and as with any sort of industry, there are players who are willing to participate at sort of the lower margin sector of the market. And I know there are projects that get financed and successfully built with single-digit returns. And I'm sure some where the stars align and everything is great, and folks are able to make more money. If you think about how real estate development works, that sometimes you find a real estate development and the factors align and it turns out to be a highly profitable venture. As far as the kind of threshold or hurdle that you're referring to, those also vary a lot by capital provider. So, there are some parties who lend money into the solar industry. And again, it's for different types of activity. It could be for the early stage development. It could be corporate debt coming in to fund the company's operations. It could be project debt on the projects. And there are different ranges that different parties look at for all of those levels of investment.
Well, you said they vary dramatically. Can you give this commission a range of what returns that you have experience with?
Well, I honestly don't have visibility into what, it's not something I do every day. I don't have visibility, and I certainly don't have visibility beyond my own personal experience. And some of this, I think, I'll say that my understanding or my belief is, just based on being in the industry for a long time, I think first of all, there are projects that get built that lose money. But one of the things I didn't mention, Mr. Burgess, is that a major factor in solar project finance is the fact that these projects are typically, unlike Dominion's projects, which have a guaranteed rate of return over the life of the asset, and with very little risk exposure. These projects are typically being financed on a relatively short-term PPA, or a PPA that's certainly far shorter than the useful life of the asset. So the ultimate return on investment, or the kind of value of the project, is highly dependent on what happens in these unknown years after the initial term of the PPA. And all project development of this sort involves taking a great deal of risk and making assumptions about what's going to happen in those out years. And we haven't reached those out years for solar development in the Carolinas. So we don't really know how this is all going to play out.
Mr. Levitas, you stated that Dominion Energy South Carolina gets a guaranteed rate of return. You do understand that's not the law when it comes to rate of return for regulating utilities. You understand that, don't you?
Yeah, I may have been a little imprecise in my choice of words, but what I mean is that there is a regulatory approved return on equity that is generally or potentially available, and also that as I said, it's available for the life of the asset, not for a time limited period. And it's available typically without regard to certain risks that we face. So for example, if a solar developer goes out to build a project and it starts installing racking in the field, and it discovers that its geotech information was inaccurate, and there's now a whole bunch of subterranean rock on that site, and it's going to cost $1 million to get that rock out of there. That is all subtracted from the bottom line of a solar development project. I suspect that in most cases, if that were to occur with an investor-owned utility, those would be deemed reasonable, prudent, unavoidable costs, and there would be no impact to the profitability of the utility in that case.
And you agree with me, would you not? That actually would be a decision that this commission would make if DESC found itself in that situation, correct?
That's right. And I'm not suggesting it would be inappropriate for DESC to be compensated in that circumstance. I'm just saying we don't get compensated in that case. That becomes a significant impact to the profitability of our projects.
That's right. You get compensated through the payment of an avoided cost, correct?
In the case of a PURPA PPA, that's correct.
And the higher the avoided cost is, the higher the return that will generate for the investors, correct?
All other things being equal, that's correct.
Thank you, Mr. Levitas. Now, last couple questions here. We'll be done, Mr. Levitas, and I appreciate your patience with me. In your direct testimony, you take issue with DESC's recommended increase in general liability insurance coverage, correct?
Yes, sir.
Can you provide this commission with a rough cost of what it would take to construct a solar generating plant of roughly 74 megawatts? How much would that typically cost?
74 megawatts AC. It's going to be north of that in millions. Is just a way to think of it. It will be more than 74 million.
Okay, so more than 74. So is it fair to say that roughly 74 megawatt AC plant will cost about $74 million to build?
It would be more than that. I just wasn't trying to do the math. I was trying to give you, I figured if it was more than 74, that would serve your purposes.
Well, more than, do you think it would be $100 million?
It might be 100 million.
More than 100?
Again, I have to get out my calculator, but.
Okay. All right. So, well, given that we can agree that maybe it would cost $100 million to build that power plant, is it your testimony, and that I want to make sure I'm clear on this, that you're telling this commission that it would be inappropriate to maintain $2 million of general liability insurance coverage?
My testimony is that the burden is on the company to come in and justify an increase. And I'm not aware of any circumstance in which this utility or any other utility, in my experience, has suffered a loss based on a casualty event at a solar plant. And where there was, I'm not aware where there's been a loss suffered, let alone one where there've been inadequate insurance coverages to protect the utility and its ratepayers from that loss. So the burden of proof is on Dominion in this proceeding.
I appreciate you saying that, Mr. Levitas, but I'm curious as to your opinion. Do you not think it would be appropriate to carry $2 million worth of insurance on a $100 million asset?
Well, insurance coverage is not my specialty. Again, my testimony on this is with regard to the fact that these values were approved. I don't believe there's been a basis provided for changing them. They do, based on my experience, are fairly typical of PPA values. So that was part of what informs that decision. But I think if the commission were to dig into it, or the company were to dig into it, and you really look at what is the risk to the company and, to your point, to its ratepayers, I'm not sure how you would even identify what that risk of loss is. As we've discussed, there's performance security with respect to damages that may be payable to the company in the event of inadequate performance by the QF. And in my mind, I'm really not aware of any risk to the company and its ratepayers from the casualty losses that are affected by this insurance. And I'm not aware of any kind of claims history. So that's kind of what's informing my thinking about that.
So is it your testimony that because you're not aware of any claims that it's not necessary to carry the appropriate amount of insurance?
My testimony that the company hasn't carried its burden of proof on this issue.
Okay. Mr. Levitas, it has been a pleasure speaking with you today. I appreciate your testimony here today, sir. Mr. Chairman, I have no further questions of this witness.
Commissioner questions.
Chairman Williams.
Commissioner Caston.
And I'll be quick and brief, I promise. Afternoon, Mr. Levitas.
Good afternoon, Commissioner Caston.
Do you agree that a LEO is an obligation, a commitment to provide energy capacity to a utility that they can plan for and use in their IRP?
I do agree that a LEO should reflect a commitment on the part of the QF. And in the 2019 proceeding, I supported a remedy or a measure of damages to make that commitment enforceable, because there have been LEO forms that didn't really have any kind of consequences for failure to perform. It is my belief that there should be a consequence for a failure to perform. So I do agree that I may have forgotten the second part of the way you phrased your question, but I do believe it should be an enforceable commitment.
That it is a legally enforceable obligation, which, as I understand it, or that would be a commitment that they could plan on, and their planning typically comes in their IRP. So if there's a LEO, they can bank on it, plan on it, and use it in their IRP, correct?
I'm sorry, Commissioner Caston, as you were speaking, I remembered the second part of the way you phrased your question, which was the reference to the IRP. And what I was going to say in response to that is that I think, I'm not 100% sure about this, but I think that utilities in the Carolinas, I think it's been true with Duke, that they have not accounted for LEO level relationships in their IRP planning. That they have looked to projects that actually have executed PPAs. But the way that the LEO process is, the way the commission has set it up and that I supported, there's a fairly short time frame from getting from the LEO to the PPA. So I'm not aware that lag would be very material for the purposes of IRP planning.
Okay, but
maybe you look a little puzzled, Commissioner. So let me just try to take one more shot at it. I view the LEO process as the first step in the contracting process. So it should be leading to the formation of a contract. And certainly once that contract is executed, it's appropriate and understandable for the utility to count contracted projects for its planning purposes.
okay, but as I've understood it, rightly or wrongly, as I've understood it, that if a QF offers a LEO, it's like sticking a stake in the ground, and that the utility has to purchase from that QF. Is that correct?
That's correct. The purpose of the LEO, which is really kind of a non-contractual or pre-contractual commitment, is to establish fixed pricing. That's what the whole thing is about with LEOs, is how does a QF developer get certainty as to the pricing that will be available to it so that it can go forward in a reasonable way with all of its development and planning activities, which cost a lot of money. So it's really all of, I mean, you could think of it, this is not exactly the construct under PURPA, but if you are analogizing to another type of business relationship, you could think of it as the point at which one party says to the other, this pricing is good for a period of time. I'm quoting you pricing, and that pricing is good, provided that you do X, provided that you execute a contract by a certain date.
So am I understanding you to say that a LEO starts a process of contract negotiation, but it's not necessarily something that the utility can count on as far as planning when, for example, they're in the beginning or they're in the midst of planning their RRP or working on their RRP, and they need that information. So if a LEO is offered, they cannot count on that in their RRP until they've worked out the contractual details. Is that what I'm hearing you say?
No, not exactly. Well, the first thing I'm saying is that it's up to the utility to decide how it is going to treat not only projects with LEOs, but projects with contracts that have never been built. People in all sorts of industries sign contracts and may not be able to perform some percentage for some reason. So it's a risk management and a planning decision for the utility to decide what assumption it's going to make about those projects coming to fruition. And that's true with respect to the LEO as well as an executed contract. As I said, I think it is a commitment to sell. Like any other commitment that a party makes, it needs, in my opinion, needs to be supported by consequences for failing to perform, and that's reflected in the current form.
Okay, thank you. And in your, I guess the discussion you just had with Mr. Burgess relative to, I guess, the NOC, I think you guys were discussing on page 15 of your direct, the bottom where you talk about first in item 4, III, Dominion DESC proposes to require the QF has either commenced construction or taken meaningful steps to obtain control of project site in order to commence construction. And second, 4IV proposes a requirement that the QF prove it has at least submitted the applications and filing fees necessary to secure all local permitting zoning. And I think that's what you've taken issue with. And as I understand it, at least from, well, I think Mr. Burgess said it and one other witness at least, that those items were directly from the FERC order, which you agreed to. I mean, which you agreed it was. Is that correct?
I agree that there is language in the FERC order that would authorize you to adopt those standards. But what I said is that it is entirely within your discretion under the FERC order to do whatever you think is fair and reasonable. You're not required to adopt that language.
Understand. I'm no attorney either. And I kind of want to say thank God about that, but I know I probably shouldn't. But that said, I'm glad we have them because they help me a lot. And
not everybody thinks that.
And as I've read myself, you know, the prior to, I think, the July 28th, 27th, 2021 FERC manual, and what was prior to that relative to this. And it seems to me that perhaps the intent was to kind of firm up what the rules are for this LEO thing. In other words, it appeared to be fairly protective or one-sided for the QF, but again, it seems to me that possibly these type additions are perhaps maybe to protect the utility some, in that it's a little more proof that you're really committed. In other words, if they're going to plan on this, and it's my understanding that that's what the Leo was, so it's a commitment. So, okay, they can plan on it. Now, you got to work out the details of the contract, but it's a commitment. So that they can plan on it and use that in their planning process. But if the QF has not taken, as it said, taken meaningful steps, in other words, maybe they haven't secured the property. Maybe they haven't even checked on what permits are required. And a host of things like that. Well, I would have concern about that too if I was looking at negotiating with someone. Would you not?
No, I would as well. I think that's a very fair point. And to your larger point about what FERC was doing in Order 872, there's no question that FERC was, well, the first and foremost thing that FERC did in Order 872 was to say to the states, you must have a LEO test, which they hadn't said before. There had been tremendous amounts of litigation about LEO formation because many states did not have a bright line test. And so there were disputes about whether the QF had done enough to establish a LEO. So FERC said in Order 872, you've got to have a test, and your test needs to measure commercial viability and financial commitment to going forward with the project. Those are the indicia of a commitment to sell. You can't make a commitment to sell if you don't have those elements. But it then said, we're going to leave it to the states to figure out in each case, each state its own test, what are the appropriate elements of coming up with a reasonable measure of when the QF has demonstrated enough viability and enough financial commitment to be able to form a LEO. And the key thing I've mentioned a couple of times, if you look at the context of this whole discussion in this long order, here's what's going on. You're balancing two things. From the ratepayer side and the utility side, FERC doesn't want LEOs to be formed so early in the process that a rate is getting locked in that's going to become stale over time, over a long period of time. And the idea is the QF shouldn't have the right to get a rate the day it decides to build a project, the day it applies for an interconnection request. On the other hand, there's a recognition that on FERC's part that if a QF does not have a firm indication of what its pricing is, at some point in the process, it's unreasonable to think QFs will ever get developed because people can't spend millions of dollars without knowing what the business opportunity is. And so that's the balance that you are now called upon to strike is, I don't want to do it too early, but we're not going to do it at the very end of the process or nobody could ever develop a QF.
That makes sense. But would it not also make sense, thinking about the customer, that if the utility has banked on the LEO of this QF, but then this QF ends up not securing the property, not securing the permits required, not being able to fulfill that obligation, and if the utility has planned on that, now they have to scramble perhaps to find it elsewhere, and perhaps it could be at a greater cost, which means the customer would have a greater cost. So would that also not be a concern, or could that also not be a concern?
I think it's a very legitimate concern. And again, I would encourage you to think about the LEO particularly as it's implemented in South Carolina, as a step on the way to a contract. So let's talk on the contract to all the concerns you just raised and to some of the questions that were asked to me by Mr. Burgess about liquidated damages. To address the concern that you have, the contract, this lengthy contract, which you all have approved, provides what happens if that seller, that QF, walks away and doesn't do what it committed to doing under the contract. There are consequences. There are substantial consequences. Significant damages, security that has to be posted to cover those damages. So that's at the contract stage. So in this, let's call it 6-month period, I can't remember if I think it's 6 months, I'm not remembering exactly the time period. In this pre-contractual phase, we've got the same consideration. It's a shorter period of time. It's going to move into the contract phase in due course. And as I said, I took the position in the last proceeding that there should be consequences for failing to perform under that circumstance. But the main thing I think to know is that it's a relatively short window that leads to the contract formation, at which point there are substantial damages, much more substantial damages for failure to perform.
So if I'm hearing you correctly, like rather than if the commission saw fit not to include all these things, but perhaps something in the contract or that the utility could put in the contract that if it fell through, there were some cost or consequences, and those things could be dealt with in the contract negotiations, which would imply to me that if a contract isn't secured, then there almost should be I don't know if I'd say it's almost like a bid bond, something along those lines. Does that make sense?
I don't remember whether the current form provides for any security but as I said, I do think it's appropriate that if a QF forms a LEO and doesn't proceed to enter into a contract unless there's extenuating circumstances, that they should incur some cost or financial measure of damages for having not done what they said they were going to do. But again, I would emphasize this is kind of the tail of the dog because it's a short period of time that is leading to contract formation. It's like I'm not sure of a good example, but I'm sure that you think of contractual examples where you're in an initial stage of a transaction and you have some consequences if you don't perform, but then you get past the due diligence period or whatever it may be, and you have much greater consequences if you don't perform. So that's the only point.
Thank you. You've been very helpful. Thank you, Mr. Levitas.
Commissioner questions for this witness.
Chairman Williams.
Commissioner Williams.
Thank you, Chairman Williams. Mr. Levitas, thank you for being here. I'm going to continue Commissioner Caston's questions and focus on the notice of commitment and in particular, your thoughts about what's meant by all local permitting and zoning approvals. Because that's really, really vast. And while y'all have been talking, I've been looking in the FERC order 872 and and the whole chicken and egg of, how do you show your commitment? But yet, and you've talked about construction permit documents or approvals not being available until a couple of weeks out. So I think my questions are, first with all local permitting and zoning approvals, do we have in the NOC form that's proposed, is it clear what that would be?
No, it's not clear. That's the basis for my objection, or to the extent it's clear, it's overly inclusive because Dominion did just pick up the Order 872 language that uses the word all. And just to make clear what I think is appropriate, by far and away, the most significant approval, particularly in South Carolina, where most of these projects don't require CPCNs, is the local land use approval. So you have to have zoning for the site. You typically have to have a conditional use permit where the local government allows that solar project to be built on that piece of property in that location. That's the biggie. Everything else is largely incidental, largely ministerial. So I will 100% agree that the developer, the QF developer, should have to have applied for its local land use approvals, which means that it has to, in order to do that, it has to have a project that is designed in a way that comports with the requirements of the local government. And that's what you're really trying to demonstrate, that you've got a real project that can be built at a particular location subject to the requirements that are there. And frankly, once you start that process going in terms of the commitment issue, there's a lot of cost associated with them. I don't know how much you've been involved with local land use approvals, but it's a time consuming and expensive process. And we spend a lot of money going through those, and you don't enter into it lightly. So you start down that road. FERC said you can't make the LEO conditioned on the approval actually having been granted, because we don't control how long that takes. But that's the main thing. It's only much later in the process, as I said, in the weeks leading up to construction, that a developer, whether it's a shopping center or a housing development, that you actually go in and say, okay, I'm now ready to go. I need a construction permit so I can start building this project. I need an electrical permit. I need a curb cut permit from DOT so I can put my driveway in. And even, I mentioned, I think in my testimony, the erosion and stormwater plan approval. That is something that comes very late in the process. And I just take you back to the goal of what FERC was trying to accomplish here in striking this balance. And the goal was definitely not to make it impossible to ever do QF development, because you can't get fixed pricing until you've already spent millions of dollars doing everything that you have to do to get to the point of beginning construction. So, I mean, I'm Mr. Burgess questioned me on this. I can't read FERC's mind. That looks to me in the context of an order like I referred to a place in my testimony where I was a little careless with my wording. The use of the word all there seems careless to me, because if you take it literally, it doesn't make sense. And it certainly, in my opinion, doesn't make sense as a policy for the state of South Carolina.
And your best guesstimate, do you when do you think this FERC decision might come out on the appeal?
I don't think the appeal is going to be resolved before the second quarter of next year.
Okay.
And there's a good chance that the resolution or appeal would require that the whole matter go back to FERC for further action if the appellants are successful. So it could be a long time before we really know where all this lands. It's worth, I'll tell you, it's worth noting that the current chairman of FERC wrote a scathing dissent in Order 872. Just mention that.
Okay. Earlier you mentioned zoning and conditional use permit. Do you have experience in South Carolina, and do you are there jurisdictions where solar farms are specified enough that you need a conditional use permit?
That's not part of what I do with my company, and so I can't really tell you the ins and outs. I know I am fairly certain that in the majority of cases we do need conditional use permits for our solar projects, and I think we've largely been successful in getting those. And we certainly work closely with the local governments to do everything that they ask to in order to both comply and in many cases go beyond compliance with their requirements.
Do you have any experience with zoning related to solar farms and where they are not anticipated in the zoning codes? How has that worked its way through the system? You know, where they're really permitted as of right.
I honestly can't speak to that in South Carolina. I will tell you that there are, my company anyway, would generally try to avoid situations where we actually need rezoning as opposed to a conditional use permit, because that's a whole other hurdle. but it's not unprecedented. There's some times where um, we, for whatever reason, may seek rezoning, and we've in some cases been successful in getting property rezoned. But generally, we're trying to find sites where solar can be built within the constraints of the existing ordinance.
Thank you very much, Mr. Levitas.
Thank you.
All right. Any questions? Any more questions? Oh, Commissioner Thomas.
Thank you, Mr. Chairman. And thank you, Mr. Levitas. I was listening to you in connection with talking about the VIC charge and the VIC true up and the possibility that the VIC could change throughout the contract period, and that sometimes creates difficulties in negotiating financing. But you also mentioned that that might be a little bit of a problem with that being in compliance with the South Carolina law. I think you were talking about section 584120F1, and that section does talk about fixed price power purchase agreements. Can you talk about that a little bit more? Just tell me what you were thinking there, and how do you or how should we reconcile that with the law?
Well, with all due respect, I don't think a contract that contains a pricing provision that is subject to adjustment several years down the road is a fixed price contract. And I've mentioned already that not only the legal requirement, but just as a practical requirement, it is very difficult to develop projects without certainty about price. I mentioned that solar development already requires financing parties to make peace with uncertainty about the future years. And that's there's all kinds of industry information and projections, but that is a risk. And in order to take those risks in the future years, it's really essential to have guaranteed contracted cash flows for some defined period of time. And that's true in all kinds of businesses. If you're finance building a shopping center, you want to know that there are leases in place and that you're going to have money coming in for a defined period of time. I'm guessing that Mr. Burgess doesn't take on a lot of legal representation where he doesn't find out for 4 years how much he's going to get paid. It's just a kind of fact of doing business. So there's the legal question and also the actual one. And frankly, we were not thrilled, frankly, that we didn't get this issue resolved in the last proceeding. We certainly thought it would be at the latest resolved in this proceeding. So whatever the number is, that it would be known, and for a period of time we could take that to the bank, so to speak. So the prospect of that not happening in this proceeding is very troubling to me and to our industry. And I'm hoping that you will give serious consideration to fixing the VIC at some number. And I mentioned that is what you have done. It was admittedly via a settlement agreement, but that's the law in South Carolina. We have a fixed VIC for all PPAs until such time as the VIC is adjusted for Duke. That's what North Carolina has done. And I would really encourage you to make your best judgment about what that appropriate number is and put it in place for a period of time, not subject to true up. And then as more work is done through whatever study you elect to do, that number then be adjusted prospectively for future PPAs.
Okay, thank you. I appreciate that. That's all I have.
Anything else for Mr. Levitas?
Mr. Chairman.
Commissioner Irvin.
Thank you, sir. Mr. Levitas, it's good to see you. I appreciate you being with us today.
Good to see you, sir.
What do you think has caused the situation where we find ourselves in where there have been no new PPA contracts for 2 years?
Well, I think the biggest factor is the low avoided cost rate, and I would say coupled with the VIC uncertainty. It is a low rate, and if we had this conversation, Mr. Cassis's testimony, well, these other contracts that had an uncertain VIC, I talked about why those could be distinguished, but one of the reasons is they had a higher PPA price, I'm pretty sure in most cases. And so you take those two things together and you take a PPA price that I think is in the low 30s, and you look at the possibility of Dominion coming in and asking for a $3 VIC or originally a $4 VIC, that's a significant percentage of the total price. So I think that's the biggest challenge. I will say, having said that, it's to some of the questions that the company has put forward in this proceeding. Avoided cost rates are what they are. We are not entitled to get an accurate avoided cost rate just because that's what we need to do projects and to make money. But we are entitled to get an accurate avoided cost rate. And I guess what I would say to you is that if you're interested in future QF development in the state or other types of solar development in the state, it's really important to get the numbers right. And both Witness Searcy and Witness Burgess have talked about various factors that go into these avoided cost calculations. So I'm not suggesting that you do anything other than call it as you see it, but I would just emphasize that where those numbers land will have a lot to do with whether the projects get developed. And so I urge you and encourage you to make every effort to consider the testimony that you've heard about some of these factors that affect the numbers.
Does an interim avoided cost rate affect a QF's ability to obtain financing or capital?
It certainly makes it harder. There are a lot of financing parties out there, and I think I remember back when most of my work was redeveloping contaminated sites, and I had a client, and they had built maybe the most successful real estate development in the state of North Carolina that was a contaminated site. They had to go to 23 financing parties to get somebody to put up the money before that project could ever get built. And I think the same is true here, that I'm not going to tell you that there's nobody that could ever be persuaded to finance a project with some level of uncertainty. It's going to depend on the project. It's going to depend on what the avoided cost rate is. But there are going to be a whole bunch of people who will just say, I'll pass on that. I'm not interested in that degree of risk.
I know you're familiar with Act 62, and you quoted a section earlier in your testimony about it requiring a fixed avoided cost rate. Do you believe that the Commission's decision to have an interim avoided cost rate violates Act 62?
With all due respect, I do. I think the VIC, it's let me step back for a second. It's called a variable integration charge, I believe is what VIC stands for. And I believe I'm correct, subject to check or being corrected, that in the prior proceeding, Dominion proposed that these variable integration costs be accounted for in two different ways. So they had a number of contracts, which you've heard about, where they were able to get folks were willing to sign contracts that said, if the Commission ever adopts a variable integration charge or includes that cost, you seller agree to pay that charge under your contract. So that was a charge. It was an additive charge. With respect to everything subsequent to that, I'm pretty sure that the company's position is that the variable integration costs are an actual element of the avoided cost rate. And so, if if it's part of avoided costs and it's subject to change based on future proceedings and future analysis, it is certainly not fixed. It's the opposite of fixed.
So does it concern you that we find ourselves in a situation where we're talking about whether or not to extend an interim avoided cost rate?
Very much so. I think, I know that the Act 62 study has not yet been performed, but I think it would be far preferable to settle on what you think is the best number based on the evidence that's in front of you at the moment, and make that applicable on a fixed basis to all existing PPAs and all PPAs that are executed until such time as you change that number, just as you have done by approving the Duke settlement and just as the North Carolina Commission has done.
Would that in fact give all the parties some certainty in terms of going forward?
It would.
And that's important, not only in obtaining financing, but also in the utilities plant for planning purposes. True?
I think it will help in that regard.
Okay. Let's switch gears just for a minute and talk about the Dominion's proposed changes to the PPA. We heard testimony earlier that Dominion had consulted with insurance brokers and others about how best to set liability limits for PPAs. That sounds to me like a bit of a conflict for an insurance broker to be making recommendations about coverage. Do you agree?
Well, I'm really not an insurance expert in terms of underwriting. So I think what you're saying makes sense, but I don't want to go too far and over my skis on that.
Let me ask it this way. Every QF is probably an LLC that has their own liability insurance coverage, true?
That's true.
And so if a QF employee is reckless or negligent in causing an accident on the highways, that's the QF responsibility, and it's insured to settle or resolve that claim, true?
That's correct.
So how does moving the liability coverage from 1 million to 2 million have anything to do with protecting the public interest, since the QF already has liability insurance coverage?
Yeah, that was part of my objection and confusion with that term. And my point is, and I could be missing something, and I would have been interested for Dominion to bring this evidence forward. I just don't think that if we're out building a project as an independent contractor and we have a truck driver who has a car accident, that anybody is going to sue Dominion, successfully sue Dominion, recover from Dominion in excess of the existing coverages. It just seems like it's a very remote sort of risk that we're being asked to provide additional insurance for without any indication that it's needed.
And in that instance, Dominion would have the right to assert a defense that the sole negligence of the QF should eliminate any kind of exposure that Dominion has. In fact, Dominion would not even be a party to that kind of claim. Is that true?
That's my belief.
Okay. Now, there was some mention by Dominion that, well, what about solar? What about storage? If you add storage to solar, that may increase the risk. What do you say about that?
Well, I'm a little unclear whether the risk that they're concerned about is a casualty loss to the facility itself, or if they're suggesting that the storage facility creates a greater risk of indirect, sort of bodily harm. The battery's going to catch on fire or something to that effect. On the first issue, which is what I would think that they would be would be the one they'd be most concerned about, is what does it mean in terms of the ability to rebuild the facility and continue to supply to them under the agreement? As I mentioned, there are already significant damages that QFs face and are required to pay if there's underperformance, as well as security that's in place, not non-insurance security, letters of credit, surety bonds, and the like, to ensure that these LLCs can make good on those kinds of obligations. So I don't see the need to protect against that risk through insurance. And then with respect to the third-party claims, again, I don't think there's any greater risk with respect to some kind of incident at a site that we're operating that's not an automobile accident of liability to Dominion.
That's right. Well, if a battery, a lithium-ion battery blew up on a QF's premises, that would be the QF's responsibility, right?
That's correct.
And Dominion doesn't own the property, correct?
Correct.
Dominion doesn't supervise the operation of the facility, correct?
Correct.
And the LLC, the QF LLC certainly would have sufficient coverage to address any kind of loss like that, true?
That's correct. And I would just point out that the parties who invest in these projects, who are putting up, as we discussed earlier, tens of millions of dollars to get these projects built, have a very strong incentive to ensure that they are able to perform and are able to respond to any sort of casualty loss or any kind of interruption of service.
In fact, an investor like that making millions of dollars in investment would be foolish to expose himself to such risk without insurance, true?
That's correct.
Okay. Now, given that background, do you have an opinion as to whether or not it's commercially reasonable to double the liability insurance coverage limits in one proceeding?
Well, thank you for the question. My testimony is that it's not. And I've tried to give you a sense of flavor why, but I think the bottom line is that I think that if Dominion wanted to come into this commission and propose these significant increases, doubling insurance coverages, that it was incumbent upon them to spell out a very detailed evidence-based case as to why the current levels were not adequate. And I just don't think they've done that.
And part of a presentation for an evidence-based case would be to show that prior claims were brought and successful, true?
Exactly.
Do you see any evidence in our record in this proceeding where there have been any claims that would impact Dominion?
I don't believe there's anything in the record to that effect, and I'm not aware of such claims being a significant issue in our industry.
And if there had been such a claim, don't you think Dominion would have brought that to our attention?
I would hope so.
Now, let's talk about some of the other requirements that Dominion has tried to impose on you, on the QFs and your association, as it relates to prior approvals. You've already talked about this, but first of all, is it reasonable to get a construction permit before you even get, well, let me ask it this way. At what point in the process would you pull a construction permit for a QF solar facility?
In the last several months of what could be a 2 or 3 year development process.
So do you think it's reasonable for Dominion or any other investor-owned utility to require you to produce a permit from a local governmental agency for construction that far in advance?
Well, they can't make us pull it earlier because that's not possible. Well, the real problem is they're trying to say that they don't want to have to give us firm pricing until we're able to pull it, which is very late in the process. And my answer to that question is, I think that's very unreasonable because we have to incur millions of dollars in development costs without being able to satisfy that condition and have certainty with respect to our pricing.
And does that interfere with the purpose of PURPA, which was created to allow QF's access to the market?
Absolutely, in my opinion. If a state were to adopt a rule that says QFs cannot get firm pricing until they are on the eve of beginning construction, that would have a devastating effect on QF development and run afoul of PURPA's goal of encouraging QF development and Act 62's goal. Now, as was pointed out, but both those laws, but certainly Act 62, seek to establish a balance between encouraging that QF development and protecting ratepayer interests. And I would just submit that making it impossible to get fixed pricing until the end of the process doesn't strike such a reasonable balance.
And that was the entire purpose of the PURPA regulations that provide for a LEO or legal obligation can be created when a QF commits all of its generation capacity to the utility, correct?
That's right. There's a recognition, and there's room for further, I guess, elaboration on this. But the basic principle is that encouraging QF development requires pricing to be known at a reasonable step in the process. And what FERC has done is left it to you and fellow state commissioners around the country to make your own determination about what that reasonable balance is.
Well, wouldn't the avoided cost rate at the time the LEO was created, wouldn't that be the applicable rate, assuming that the LEO is valid under PURPA regs? Wouldn't that be the applicable rate?
That's correct.
And so it would disadvantage QFs to have to wait 2 or 3 years to find out what the applicable rate is. Otherwise, true?
That's exactly the problem. Correct.
And because what bank would want to lend to a QF not knowing what the rate of return would be? Is that right?
That's the problem, correct.
Okay. Finally, as you're aware, in our last avoided cost proceeding, the commission was persuaded by the fact that we might benefit from a VIC study, which unfortunately has not even begun. And it's now our understanding that it could be costly, it could take time. What is your association's position? Do you think the commission would benefit from such a study? Or do you think it's more important to go ahead and lock in an avoided cost rate going forward?
Well, I would say both and. So the calculation and analysis of variable integration costs is going to change over time. It's going to be ongoing. The methodology is going to improve. So I certainly would encourage you to proceed with the study, provided that that is not paired with maintaining an interim VIC in the meantime that is subject to true up. So what I think the right course of action, again, this is what's been done with Duke, is to fix a VIC now based on the best evidence before you and your judgment about what to do with that evidence and information, and have that be applicable until such time as additional study is done. And just to be clear, again, what has been done with Duke in both the Carolinas is that for any existing PPA that is subject to a VIC, or any PPA that is entered into, until such time as that new VIC is established, that the existing VIC fixed VIC would apply. And then upon PPA renewal, the QF or the developer would be subject to whatever VIC is in place at that point in time.
And so what I hear you saying is that perhaps we should take the docket under advisement until we can get Office of Regulatory staff to get a VIC study, and then consider that as part of a final determination, or is that what you're suggesting?
Well, not exactly, unless there's some additional work that could be done in very short order. My recommendation would be for the commission to make a decision based on the record before it. You have a lot of information. You have the Guidehouse report. You have testimony from witness Cersei and witness Burgess. You're going to, I believe, have your own independent expert in this proceeding who's going to assess the evidence in the record. And just as you determined 2 years ago that 96 cents was the best number that was available to you at the time, I believe you can make a similar determination, whatever that number may be, with the difference being this time, as I said, that number should become fixed for the life of PPAs until such time as a new VIC is established, which would apply to PPAs formed after that point in time. And again, what I'm recommending is exactly what has been done in Duke's service territory.
Now, it's my understanding that the parties, or at least most of the parties, have agreed and stipulated that 86 cents per kilowatt hour would be an appropriate interim avoided cost rate. Is that correct?
I don't believe it's the case that CCEBA or Pinegate, and perhaps not SACE and CCL, have stipulated that the establishment of any interim VIC would be appropriate. And what I'm suggesting to you now is that CCEBA's position is that there should not be an interim VIC at any level, that there should be a fixed VIC.
Yes, sir. Let me ask you another way. Could your association live with that number as a fixed VIC rate until such time as we get the study and consider avoided costs in the next docket?
That is not something that we have discussed as an association. And of course, we have an expert witness, Mr. Burgess in this case, who has suggested that different numbers are appropriate. So we would need to talk about that. But I will tell you that the approach that I've described, which I've said several times, has been adopted by Duke via settlement in North Carolina and South Carolina. I think this issue is amenable to settlement, or should be amenable to settlement. If the parties are not willing to reach a settlement on a fixed number coming out of this proceeding, then I would suggest that it would fall to you to determine what that number should be. But our association did stipulate to a fixed number with Duke in the last proceeding. That number in the settlement for the current Duke avoided cost proceeding is being extended further, again, as a fixed number. To be honest, in North Carolina, which preceded the last South Carolina proceeding, Duke entered into a settlement with the North Carolina public staff that our industry opposed. We weren't successful on that. And so it was the Duke public staff settlement that became the fixed VIC. And then at that point, we did agree to it and stipulate to it here in South Carolina twice.
So what I hear you saying is that while you're not ready to commit to that particular rate as a fixed rate, you would be willing to consider it and discuss it with your legal representatives and your association in hopes of perhaps reaching a settlement agreement as it relates to the fixed VIC.
Yes, sir.
Thank you. No further questions.
All right. Any more questions for Mr. Levitas? Sir, I have a few questions for you before we end the day. I think I remember you testifying that if solar QFs are to come online, then it's important for the commission to select the most accurate avoided cost. And I'm not reading your testimony here, but I remember you saying something to that nature, essentially.
Yes, sir.
Okay. And so I don't know how much of the hearing you've had opportunity to listen to, but you would agree throughout the course of this hearing, the transparency of the applicants, Dominion Energy South Carolina's models, forecasting, inputs. There have been accusations that there was room for more transparency. Do you remember hearing any testimony regarding transparency?
I have heard some of that testimony, Mr. Chairman. Yes, sir.
Okay. So it just makes me wonder, would you accept, let's just say in a perfect world, if the commission was not just a court to make a decision on this matter, let's just say we reached beyond that and said, you know what, why don't Dominion run the solar interveners inputs through their models, right? Just run their numbers and see what happens, right? If we could do that. And it turns out that avoided cost is less than what you think it should be. Are you willing to accept those numbers and the outcome or result of those numbers, in that maybe the avoided cost is just not as high as you think it is, or arguably not as high as you want it to be in order to attract investment into solar QFs?
Well, I'm certainly prepared to accept the possibility that properly calculated avoided costs may not be as high as we would like them to be, and may not be high enough to support QF financing. But to your point, as an example, I believe it's the case that in the Dominion IRP proceeding, that this commission ruled that the methodology that was used for forecasting gas prices was inappropriate, and you required Dominion to use methodology that had been advanced by interveners. And I think we're here in this proceeding with at least a somewhat similar issue being presented. And so, my hope is that those numbers would be recalculated using different inputs.
Okay. And I appreciate that, but you are at least willing to concede that at some point, possibly, if the inputs are ran in the models, that if they do turn out to be lower than expected, the commission can't, in good faith, order a higher avoided cost to support solar QFs. Support investment in solar QFs, can they? Or can we?
No, I absolutely agree with that, but I would make two sort of caveats or qualifications. The first is that it is within the commission's discretion to determine the period over which avoided costs are to be calculated. That can have some bearing on the output or the outcome. But maybe more importantly, I just want to speak to the fact that PURPA QF development is one pathway for bringing clean, renewable energy to the state of South Carolina. It's a corporate objective of both the major utilities and Santee Cooper, for that matter. There's huge customer demand for it. And so I would just encourage the commission to be looking, I hope that PURPA does provide a viable pathway. If it turns out that it doesn't, if you do what you just described and the numbers don't work, then I think we have to turn our attention to some of these other pathways, including the competitive procurement of renewable energy that you're authorized to explore under Act 62. And you may recall I was a witness in that proceeding, and I look forward to continued work on that front. But to answer your question directly, no, sir, I do not think you have I do not have the expectation that the commission is going to disregard the evidence and establish an avoided cost rate that is not supported by the evidence just because that might be necessary to support QF development.
Understood, sir. And I'll tell you this, I appreciate your honesty during this line of questioning, because you alluded to my next question in that if it were the case that the awarded cost is not as high as you think it is today, there would be another pathway offered to expand, right?
Yep. Are you referring to competitive solicitation?
Yes, sir. Or any other method that's available.
Yes, sir. Yes, I personally have been a staunch proponent of competitive solicitation, and not meaning to take anything away from PURPA, which has been a very valuable tool in the toolbox for many years. I was an active supporter of North Carolina's transition to what is now a competitive solicitation paradigm rather than a PURPA paradigm. I've been supportive of that at the national level. So we want to get this proceeding right, but I believe that much of the future of renewable energy development lies in competitive procurement.
Understood. Thank you, sir, for your testimony. Is there any redirect?
Mr. Chairman, there's no redirect, and we'd like to have Mr. Levitas excused if the chairman will allow that.
Oh, absolutely. Mr. Levitas is excused.
Thank you, Mr. Chairman. Thank you.
All right, ladies and gentlemen, we've come to the end of our day. Tomorrow we will reconvene at 1 p.m. The first witness will be ORS's witness. I believe that's Morgan, witness Morgan. Is that correct, Attorney Huber?
Yes, Mr. Chairman, that's correct.
All right. Thank you, ladies and gentlemen. We will see you tomorrow afternoon at 1 p.m. We are adjourned.
Thank you.